or does anybody know this? So to consist of a quorum for an executive session, we clearly have enough people here to have a hearing. But if we don't have a single member of the Democratic caucus in attendance, how does this work?
Oh, let's call the clerk.
All right, ITL. No, I'm just kidding.
Let me,
I make a motion
second.
to.
I'm gonna call the clerk.
Okay.
Morning. Well, first let's start, if you wouldn't mind joining me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Did you open the hearing, the exec? Did you open this as exec?
I just opened this.
Okay, we are back in House Bill 1012, executive session, and I recognize Representative Reed to make a motion.
Thank you, Mr. Chairman. I motion to OTP House Bill 1012. I make an OTP motion on House Bill 1012 FN.
Would you like to speak to your motion?
I would. I like this bill because every parent knows their child, and everybody has different opinions of what is safe and not safe for a child to do. And I think this bill protects parents' choice in what they allowed their children to safely do. I see this as a nice protection. Thank you.
Thank you, Representative Tenzar. Would you like to speak to your second?
I'd just like to say concur with Representative Reed and well said.
Thank you. Discussion. Representative Murray.
Thank you, Mr. Chair. I have some concerns with this bill in terms of just creating a blanket exception that doesn't really seem necessary, in my opinion. I did try to work with the sponsor on an amendment to address the concerns that were raised by Attorney Enders and New Futures, and she was not willing to make the changes we discussed. And so because of that, I will be voting against this bill, and I would urge others to do the same.
Further discussion. What?
Can you clarify? There are guidelines, guardrails in here to protect the child. If a parent can present their rationale for allowing a child to do a certain activity, I mean, there's common sense built into this as well.
The specific point that Attorney Enders raised was, I think it was, I don't have the text of the bill in front of me, if you give me just 1 second, but that it said parents can't be, charged, I guess, if no actual harm was done to the child. And in Attorney Enders' opinion and in mine, usually we want to stop harm before it happens and not wait until a child has been harmed to intercede.
Representative Prue.
So I know I may be older than dirt, but this is kind of like how I grew up. I had to be home when the street lights came on. Nobody was helicoptering over me, making sure everything was okay. We used to run around in the woods and all kinds of stuff. So I think just let's parents go back to that, because somewhere along the way, we have decided that our children cannot do anything unless we're 2 feet away from them, watching them. They don't get any life experiences. You got to scrape your knees a few times and to figure out not to do that. So if you don't have these life experiences growing up, then you won't be ready for real life when you turn 18.
Thank you. My concern is that a bill that says it's actually creating an exemption that encourages freedom in children actually seems like it has the potential to actually put kids into more danger. And I think the reason for that is the bill really doesn't specify what types of endangerment activities would be covered under the law. So I know the sponsor's intent was to create a bill that addressed what she thinks is an overly broad statute. But I think the way to address a statute that you think is overly broad isn't by replacing it with another statute that's equally broad. Thank you.
Representative Reed, there's been an amendment proposed to this bill by the sponsor, and it makes a change to the last sentence. If you wouldn't mind, Representative Murray, could you please call out the difference in the amendment?
Thank you, Mr. Chair. From comparing the text, the only difference I see is the added lines of 13 and 14, which adds a new section that says it is not a violation of the section for parents to allow children to take reasonable risks to further their development as independent human beings.
Thank you. No, I'm about to pass it out. Could you pass that to the left and right? It hasn't been introduced yet. I'm going to ask if Representative Reed would withdraw her OTP motion and then make an introduce the amendment. If that would be okay. Do you withdraw?
Yes,
And you withdraw your second? The amendment's coming around. We know that it's just a one change, one sentence change that I believe that she made after conferring with several people, I think, at the AG's office, but I'm not sure. Now that you have it, if you could just look at the addition is sentence 13 and 14 at the end. So I recognize Representative Reed to make a motion.
I motion to ought to pass on amendment 0504H.
Second, Representative Tenzar. We're still in basically the same discussion. Anyone have anything further to add based on the one sentence? Otherwise, Representative Reed.
I still believe that life is dangerous. There's no guarantee that any of our activities are not going to end in us getting hurt, falling down the stairs, cutting a bagel. All of those things can be dangerous. I think that parents, we should give them credit for common sense and knowing their children. And I think it's better for child development for them to be able to be kids than to have constant fear of getting hurt and being hovered over. And I think this bill is long overdue and we should pass it. Thank you.
Representative Murray.
Thank you, Mr. Chair. I feel like people are thinking of like a specific set of circumstances with this bill. I have no problem with kids running around outside, and I did that as well when I was a kid. And as far as I understand, that's not currently outlawed. But the guidelines here are just so broad, and it mentions actual injury or harm that doesn't account for any potential mental or emotional distress that may happen to a child due to parental decisions or parental neglect. I just to share some of my own experience, grew up going to a church that my parents were unfortunately manipulated into because of their own circumstances growing up and fears they had about me being out in the world. And in that church, many of the kids were not allowed to get to know any other kids their own age. We were all homeschooled. We were not allowed to engage with the world in a way that is necessary for kids growing up. And I just don't think this is taking into account, like, according to this, you know, this feels like it would leave an exception for parents who want to just like keep their kid in the house all day long, all year round, and never see another human being. That would be allowed with this bill. And there's just no account for the like mental and emotional well-being of these kids. And I just feel like, again, the guidelines are just so broad. I just don't understand why we need to make an exemption when we already have laws that make clear what's a crime and what's not a crime.
Thank you. Just for the record, I was kept inside my entire childhood, and look how I turned out. Representative Lynn, I would like to invite you to give us a class. Everyone, hearken and listen to the former Supreme Court Justice on a class of statutory construction. Could you tell us, please, when you have a colon after an offense under this section, if, then we have A, B, C, and D. What do the colons or semicolons mean after each sentence, A, B, C? And because at sentence C, I noticed colon and. So I'm reading the other semicolons to read or.
I think it means that you have to, in order to satisfy Roman numeral 7, you have to satisfy all 4 arms. I mean, that would be the normal, I think the normal way it would be read by a court.
Okay. So just for clarification, no parent or legal guardian of a child who makes a parenting decision shall be guilty of an offense under this section if A, there's no actual injury or harm, and no actual injury or harm is the result of an unavoidable or unforeseen accident. If that section A is not satisfied, does then the rest not matter? It's irrelevant?
I think you, in other words, in order for this to invoke this section, I think you have to satisfy all 4. So, I mean, so for example, if there was no actual injury or harm, you wouldn't satisfy this section. Now, maybe that would still mean. Oh, I'm sorry.
The whole class has to.
Sorry about that. If you didn't satisfy, let's say A, your example, then you wouldn't satisfy this section. That, I don't think that necessarily means that what you've done is a crime. You may not satisfy all of the sections of whatever provision would make it a crime, but
Right.
you wouldn't satisfy this unless you met all 4 of them.
So I guess here's a question. I'm trying to get an example. For example, there's a reasoned approach. Let's go to C, to such a decision making that takes into consideration risk versus benefit. If I did decide to keep my child sequestered, never let them out, would I then not get the protections of this because there's really not a reasoned approach to do such a thing? Or would I still be protected because there was no injury proven to the child because I kept them locked up inside? Right. Sure.
I mean, if there was, I think harm doesn't necessarily mean physical harm only. If there was emotional or,
Okay.
harm, that kind of thing, I think that could be harm.
So a child left alone, for example, who was traumatized by that, they could still be charged with neglect because of the first sentence A.
Right.
If it
I
was-
mean, if the other, right, exactly. Yes.
Okay.
Yeah. No, I think that's right. I think
Okay.
that's right. Yes.
All right. So, in my opinion, if someone does something so irresponsible with their child that it results in emotional harm, physical harm, or even if it's just potential physical danger, but still gives them emotional trauma, and that's picked up at either at school or however, it's a doctor, they can still be charged with neglect because of that word harm. So I think that answers a lot of the questions we've heard. It doesn't, maybe not satisfying to everybody, but I just wanted to point it out. Further discussion, Representative Selig and then Bolden.
Thank you. I oppose the underlying bill as well as the amendment because to me it feels hypocritical if we're not allowing parents to make medical decisions for their children based on their children's needs, which we've blocked as a house, then it seems to me that this bill is also unnecessary. And so it just feels like a hypocritical. We want to have our cake and eat it too, and I don't think that's appropriate.
Representative Bolden.
I really want to push back really hard against the idea that it's possible to prove emotional or psychological harm. I'm not aware of any cases in the family court system where that's been proven. Therapists are, they typically will require during the process of, setting up a new patient file, they'll require signing a contract that says you won't make the therapist go to court. The judges in New Hampshire, there's a bill, I think in Child and Family right now where I don't remember if it got voted on yesterday, but where they're sort of begging judges to give more consideration to the views of the children. It's extraordinarily difficult to bring in any kind of testimony from a mental health expert on psychological or emotional harm. And it seems like this would set it up so that someone who is causing that, because it's so difficult to prove that they're causing that, would get off scot-free. And I can't stress enough the immense difficulty in proving psychological or emotional harm. But I don't know if maybe Representative Lynn wants to speak. I don't know if he was ever in the family court.
Thank you. I would suggest that you probably are correct, but you're missing the point that we're talking about a criminal statute, which would be the neglect statute. So the contract is irrelevant. It could be brought in. The testimony and all the evidence could be brought in because the criminal statute would trump that. In a civil case, I agree. If it was a custody case or something like that, it's very difficult. But a criminal case, that evidence would be allowed. Justice Lynn, Representative Lynn, would you like to speak to that?
Well, I guess I would say that I think I agree that it is difficult to prove emotional harm, or it often can be, particularly in the context of, if you had some kind of a malpractice case or a case that was sort of specifically focused on that, and there was time to get experts and all that. Maybe it's not as difficult, but I think I agree with you in the context of a criminal case is probably, that probably is true. I guess when I believe this was Representative Leakus' bill or
No, it was Representative Cushman.
Cushman, I'm sorry, Representative Cushman. What somebody spoke to me about this bill, and one of the things that I said, the reason that I thought it was that something like this, I'm not particularly married to any specific language, but something like this was important, is it just seemed to me it did make sense to have something in the law to say that the legislature recognizes, or the law recognizes, that we can go too far in trying to protect children and really end up harming them because you restrict them so much that they don't have a chance to live. And I think it's important to have something in the law just to say that. The specifics of exactly how it's worded, I personally think this is fine, but it doesn't have to be this. I just think having something that says it's okay for parents to let their kids take risks is an important thing to say.
Thank you. I did some research myself, and 8 other states have passed laws like this that they've gained the moniker of free range parenting, I believe. I see you, Representative Jambrin, first.
Thank you, Mr. Chairman. I see this bill as in a totally different way. As somebody that grew up with their parents absent and grew up with my grandmother, she was very. She allowed me to do a lot of things that normal parents, I shouldn't say normal parents, but a parent may not allow. So I'll give you an example. On Friday afternoon, get home from school, throw a thing of bologna and a loaf of bread into a backpack, throw it on my BMX bike, grab my tackle box and a tent, and go. I don't come back until Sunday night. She has no idea where I am, but she knows that I'm out fishing. And I take my cousin with me, of course. So I see this as that parent that allows that to happen is not going to be prosecuted for neglect. Hey, where's your kid? I don't know. They're out fishing. They're going to be gone for the weekend. And you know what? That was before we had cell phones, so she couldn't track me on GPS, couldn't call me on the phone. But she knew if I was in trouble that I knew how to get help. So I see this bill as allowing that type of relationship with a parent. I don't see it in the light that you folks are here. I don't understand. I understand where you're coming from, but I see it differently.
Representative Newell.
Thank you, Mr. Chair. I completely agree. I love the idea of letting my kids take risks and learn their lumps, get their lumps and learn their lessons. I wanted to ask a question of Representative Lynn, since we're all drawing on his expertise. And my question is, when when it says in here that one of the kind of premises here is there is a reasoned approach to such decision making that takes into consideration benefit versus risk. And what I get stuck on with that is reasoned, because everyone who goes into a courtroom has a reason, right? Everybody's got a reason. Everybody's got their reasoning. It doesn't say anything about what the quality of that reasoning is, or kind of what the standard is that we would hold that reasoning to. I would think it would need to be a good argument, which in other words is reasoning. Am I right?
Well, I guess I think the way I maybe would respond to that is this. I think that what it's designed to get at, I mean, I didn't draft this, but what I think it's maybe what it's designed to get at is that to say that the person thought about it. And even if, even if the person was, well, even if you might disagree with their reasoning, at least they thought about it. So that, for example, if the kid left in the hot car, if the parents said, well, look, I literally was going in to buy a package of gum at the 7-Eleven, and the store wasn't crowded, and so, I didn't think about it long, but I did think it was only going to take me like, a minute and a half to do this. I would say that's a reason, you thought about it, as opposed to something that you just, geez, I never even thought about, I forgot my kid was in the car. I didn't realize that my kid was in the back, or something like that. You might say, wait a minute, that's like, geez, you didn't know that? That's, so I'm not sure that's a great example, but I want to emphasize, I don't think I have any particular any expertise as to sort of reading, better expertise than anybody else as to sort of reading language, because it's, you're all smart people. You can draw your own conclusions from the language, I would say.
Representative Mannion.
Thank you, Mr. Chair. So I'm not as old as Representative Prue, nor have I ever fallen down the stairs while cutting a bagel. But I grew up in the 70s and 80s, and I used to race BMX bikes in a sanction, in a league. It wasn't just a couple of kids in the dirt. It was actually sanctioned. We traveled around a bit. So as a result, my son started racing when he was 9. I introduced him to the sport because the baseball just wasn't doing it for him. BMX is an individual sport. You win, you get the praise, you lose, it's on you. So he became state champion in Mass, district champion in New Hampshire. But along the way, he's had concussions, sprained ankles. He broke his wrist. We were in Baltimore in a hospital. Am I now negligent because he got hurt while entertaining these? And he raced nationally. So my fear is that parents who are having their kids in sanctioned sports, are they going to be able to be charged with this stuff? This would cover it. As far as emotional damage, I guess, aside from severe stuff, he would win and feel good. He would lose and feel bad. And I would talk to him about losing and what he needs to do to get better at it. Part of emotional roller coasters and emotional feelings are part of growing up. It's part of your character. It makes you who you are. So there needs to be some degree of that happening to these kids while they're children. So when they're adults, they're better able to cope with this stuff. So I think this bill's good, and I'm gonna vote to OTP.
Representative Wheeler.
Thank you, Mr. Chairman. I didn't get a chance to discuss this in caucus, so let me just say no surprises, Ray. I did text Linda about this. But, Mr. Chairman, I support this legislation, as I think Representative Lynn made the point better than I could have. There's no statute in law currently, after reading RSA 639:3, that says that the law respects that children have a right to grow up in interesting scenarios. It's not always easy, and it doesn't repeal anything that's already in 639:3. That statute is very well written, I think, and does illustrate what we are talking about here today. It's child endangerment is wrong, and it's illegal under that statute. This adds language to that statute which says that parents ultimately have the right and freedom to raise their children. If it goes too far, then the sections in that statute prior to that would come into play. So, Mr. Chairman, I grew up the same way as many of us have said. It was in the early 2000s, but I grew up in It was just yesterday. It's still a baby.
Do you want to
but-
withdraw the "I grew up" part? or-
yeah, right. There you. I am alive because yeah, I don't know if I've necessarily grown up yet. I think you're right, Mr. Chairman, but I do support this legislation, and I will be voting yes on the OTP.
Thank you. And before I take other questions, I just want to add something that I think that you really hit on that's very important. We should not read this bill in isolation. This is part of a broader statute that already covers a lot of scenarios that would make a parent's actions illegal. And this section clearly says if it's not in violation of any other law. So therefore, a lot of the concerns we're hearing about are already covered in law in the rest of the statute. So up next, Representative Murphy.
Thank you, Mr. Chairman. I have the same concerns that Representative Newell has. And actually, if I understand Representative Lynn's explanation, so A through D would all have to be satisfied for a determination of endangering the welfare of a child. Is that correct?
Sorry, yes. In other words, if you wanted to satisfy 7, I think the way it's worded
Yep.
with the semicolons and the "and," I think you'd have to satisfy all of those.
Okay, thank you. Which actually confirms my concern. My concern, having worked at DCYF with parents of all sorts and children of all sorts, is that this part of the statute would be used to legitimize neglect. I think it limits the discretion of our judiciary. I think right now our judges have the ability to take these things into consideration, and I think my sense is that it will complicate things. The words actual, reasoned, I do know how challenging it is to, having been worked at DCYF, having been a foster parent and adoptive parent, to prove actual injury or harm. Injury, maybe if it's physical, it's easier, but harm. I don't know. I don't think I could support this. I recognize that parents, we all let our kids take risks. We use our own discretion, but sometimes the discretion that brings a parent to the attention of a court may be different than what we would think of within a normal realm of discretion. I'm afraid that children will be hurt by this, and so I'm not going to support it. Thank you.
Thank you. I just want to make a point, Representative Murphy. By having to satisfy all of those, that's actually makes it tougher on the parent. In other words, if you don't satisfy all of those, it doesn't make you exempt. It says no parent or legal guardian of a child who makes parenting decisions shall be guilty of an offense under this section if. So the only way they can be not guilty of an offense is if they satisfy all those. It's not the other way around. So in order to avail themselves of this, they would have to say, okay, my child wasn't hurt. The decision wasn't in violation of law, and I have this reasoned approach in the decision-making part, and it's keeping with the family guardian's values. So I just wanted to make that point. You may respond.
Oh, thank you. I think I understand that, but my concern is, okay, if we don't prove, or we just say you prove actual injury, or you miraculously somehow prove harm, a reasoned approach and taking into consideration the benefit versus risk aligns there with Part D, with the parent or guardian's values. Once
the injury occurs, they're done. They can't use the rest of these, is what my point is. So if the child is injured, you can't say, yeah, they're injured, but it was reasoned approach. It was, you know what I mean? They have to satisfy all those.
I am confused. By
Yeah,
this.
I know.
So it's not. It should. If that were the case, then wouldn't that say or after A?
Well, that's what the semicolon is for, I believe. And we can go back into class.
They're all.
If it says or, that means it individualizes each of them.
Right.
So if it says or, it's only one A, B, C, or D.
That exactly.
It doesn't say that, which means it has to be all of them.
Right.
Right. So that's, but if you're saying that all we have to do is prove harm or injury, then the rest don't matter. But that's,
Yeah.
if the colon is there,
Yeah. So in other words, okay, let's put yourself in a DCYF position. You're back at work.
Yep.
You have a kid and you think you're doing an investigation and the kid has injury. The parent can't use this statute. It's already done because they have the injury. They can't satisfy all those. Do you see what I mean? So, or if you don't find any injury, but it's a violation of one of the other sections of the law, they can't use this. Or if it's not a violation of any of the laws and there is no injury, but they don't have a reasoned approach. They said, I saw something on a TV show I thought would be cool to do with my kids. They can't use this. Yeah, it's got to be, they have to get all these in order to say you can't prosecute me for being negligent. Any one of these, and they're done. Let me see who was up. Representative Prue. And just for your information, I see all the hands. We're writing them down. I'm letting people who haven't gone yet go first. Okay. Representative Newman.
My concern with the law is we're writing a specific exception to say you shall not be guilty. We don't do that for a lot of laws. We should do it for a specific reason. I haven't heard the reason yet. I've looked at all the testimony that's gone forward about they let the kids play football, they got injured, they did all this kind of stuff. I just think I don't understand, and I don't like these broad exceptions. You shall not be guilty because. So that's my problem with this law.
Thank you.
And I do take a point of personal privilege. My name was used by Representative Wheeler, and I just want to let the committee know I am seldom surprised by anything he does.
We know that to be true.
And that is noted for the record. Representative Bolden, we're back to you. Who else is, Representative Muse, I see you down there.
I just have a question if anyone on the committee wants to speak to this. Gender reassignment surgery is not illegal. And the bill that was passed by the House recently with your name attached to it, as I understand, makes it a criminal act on the part of the physician, but not the authorizing parent. So, given that surgery isn't injury or harm, but a medical procedure that is illegal, much like a circumcision is a surgery, the parenting decision is not in violation of a law. There's a reasoned approach that takes into consideration benefit versus risk. As I understand it, typically it's a last resort when the mental health of the child is at risk. And it's in a decision made in keeping with the parent or guardian's family values. Would this explicitly allow for gender reassignment surgery for minors?
Well, as long as it's not in violation of another law, I would say there's a reasonable argument to be made for that, yeah.
And we currently don't have a law against it. And if that bill were to pass the Senate and not be vetoed by the governor, it still would not be illegal for the parent to consent to that on behalf of the minor?
That I don't know. I slept at a Holiday Inn last night, but I'm not an attorney. But it's an interesting line of questioning. I'm glad you brought it up. Representative Muse.
I just want to say we should be extremely careful in modifying a statute like this. This is the endangering the welfare of a child statute, and like our domestic violence statute, these statutes were put together with the idea of protecting people who are potential victims and who are vulnerable. And it just strikes me as strange that in a statute like this, we would be creating an exception for anybody. It just doesn't seem to be like something that we should be doing. And I think Representative Bolden and Murphy have raised some excellent points. And one of the things that I think that this statute can do potentially is to legitimize neglect. And I think that it opens the door to some unintended consequences that the sponsors, and I think some of the folks in this committee, may not necessarily be in favor of. I just think it's something that we need to look at a lot harder before we pass it.
Thank you. Let me see. Oh, I would also remind everyone, and I'm not going to say anybody's name or anything, but we do have another bill that's before us that makes exemptions for parents in jail sentences. So when we start saying, well, we don't like making exceptions for anyone for anything, I would remind you of what else we have before us. Representative Rhodes.
Thank you, Mr. Chairman. So I would like to address some of the very specific things that have been brought up with this discussion. And when this bill first came in front of us, I absolutely hated it. I thought this was not necessary. I personally didn't think there was a very good argument made of any reason why we should pass it. And then I started looking into some of the situations that have been brought up today. So I know it shocks some people to know that I guess that I have a life outside of here, but I do. And one of the things that I unfortunately have to look at are the court papers for child abuse and child neglect cases. And pretty much everything that has been said, I can assure you, absolutely is illegal. It will not be illegal if this bill were to pass. And if you have a situation where, God forbid, a parent throws their child into a basement and literally throws down a bag of bread for days at a time, that is illegal. And this bill will not make that be legal by any means. And you actually are able to prove emotional harm. I know that for a fact because at my desk, I have about 6 court documents right now that are all that. They're emotional abuse, they're verbal abuse, neglect. And at the end of the day, even if there's a parent that you really just don't think is a very good parent, it's amazing if you start talking about their child, they do love their child. There are very, very few exceptions in this world where the person does not love their child so much that they're going to put them in actual harm's way. And I think that that is what this bill was trying to address, was that, you know, you went into, I personally will not go into a convenience store and leave my purse in the car. Why would I leave my kid in the car if I won't leave my purse in the car? My kid's worth more than my purse. But people choose to do that. Should it be illegal? Probably not. Probably not. And I think that that's what this bill was trying to address. So I just would like everybody to keep that in mind when you're voting on it. Thank you, Mr. Chairman.
Okay, with that, I think everyone's had a chance to speak. Well, who's left? Oh, Representative Sitek, you have not.
Yes, I have no wish to be unpleasant, but I'm going to be, I guess. First, I think, unlike Representative Newman, I think that Section 8 improves the situation, but I still don't like the bill. It strikes me that I do not know of any particular instance that this is trying to cure. It fattens the books for basically what seems to me to be, I can't articulate this, but it feels like a loyalty oath somehow. Everything seems to be illegal that the people have talked about without reference to this. This doesn't cure or fix anything. I don't know. It's trying to capture a mood. It's trying to turn back what society seems to be. We're going to sue you because you you tripped over the crack in the sidewalk. There just seems to be this is a reaction to a societal trend, and I don't like the societal trend, but I don't think this is going to change it either. So I'll vote for the amendment, not the bill. On those, rather, I wish I had expressed it better. I'm sorry I wasn't around to discuss this earlier.
Thank you. Oh, sure, Representative Harriet Gathright.
Thank you, Mr. Chair. I was just looking at some of the notes from that hearing, and I just want it made known that there was issues with this bill with the county attorney that was here that day from Merrimack, and you you had at that time asked him, does he see this happening often? And he says quite often. He said that endangering of a minor welfare charge is fairly regularly on a misdemeanor level. And he quoted 639(3), Section 4, to back up what he was saying. I also remember that there was another group that was against the bill as well. New Futures, that's what it was, yes. So with that said, I can't support the bill as it reads now.
Thank you. As this is a very important bill, and I would like to see if there's a way. It seems like we have a lot of people for it, a lot of people against it. If there's any way that we could amend the bill so that we could get broader support, because I don't like party line bills to do with children. And I'm wondering, and I'm going to ask Representative Lynn, there's this whole broad thing about, if it's in keeping with their values and if they have a reasoned decision. Many of our criminal laws and even civil laws have what's called the reasonable man or reasonable police officer, would a reasonable parent addition to this make it still allow for protections of a parent, but still set sort of a societal guideline? Would that be helpful, you think?
Well, I think it might. One thing that you could consider, as I said before, I think to me the most important thing is to have, because I agree completely with Representative Seitek, although I don't agree with the result he would reach. I think that the reason that you need something like this in the law is that we have become, there is, a mentality, at least in some quarters out there, that we should be helicopter parents, and you shouldn't let your child take any risk. And and particularly if a child gets hurt, then we really want to use 20/20 hindsight to say, oh, you shouldn't have taken that risk, or whatever. And so I think there ought to be something in the law that addresses that. And what I'm wondering is, suppose you took out paragraph 7 altogether and just left in paragraph 8. That does sort of say, look, it's okay for parents to take reasonable risks. And this is something I remember I'm 74 years old, so it's a long time ago.
No.
But I'll give you when I was like in 7th grade, I think it was 7th grade, back in West Haven, Connecticut, there was this guy that was this other student that was constantly picking on me, and he had probably more friends than I did, and I was really kind of a wimp, and so I was raised by my mother and my great grandmother, and I kind of was I was really afraid, frankly, and I sort of said to my mother, well, I'm really having this trouble, and she was thinking, I should go to the school authority. And I said, no, you can't do that. It'll just make it just worse for me if you do that kind of thing. And my great grandmother, who we lived with, who was, God, she had to be in her 70s by then. She said, I think you just need to take this guy on. I think you just, maybe you'll get a punch in the nose, but in the end, that may be the best thing. And so that's what I did. And we literally had a physical fight, and we both inflicted a little damage. Nobody got hurt in any significantly, but we both got bloodied a little bit. And after that, that was the end. We didn't become friends, but that was the end of him picking on me. And so I guess the question, in that situation, should my great grandmother be charged with neglect? If a police officer came along and found that I had a bloody nose or whatever, and you talked to me, and I said, oh well, my great grandmother said, look, I think this is the right thing to do. You might get a punch in the nose, but maybe this will end it if this guy at least knows that you're not gonna, you're willing to stand up to him. And it turned out she was right. But would a police officer now or a prosecutor say, boy, she, great grandmother encouraged him to have a fight, let's lock her up? I hope not. But I think that's the thing, that there ought to be something in the law that says if the police, if that kind of situation comes up, the police are going to think twice about charging my great grandmother with a crime.
Thank you. And I just wanted to, that's a very good point, and I like that idea. Maybe just strike that, that whole thing and just leave the amended piece. That just leaves it for the court to decide, but says this is our preference. And I wanted to, and as an example, Representative Bolden had brought up the transgender issue, and I just saw in the news in California, the state had taken children away from their parents because they refused to use pronouns. Again, I mean, is that endangerment? Is that because I don't know, but I think we need some guidelines, and I agree. Representative Murray, you have your hand raised?
Thank you, Mr. Chair. I wanted to say that I like Representative Lynn's proposal, and I actually was going to suggest the same thing. I think my biggest concern with the bill is the kind of loopholes that the guidelines here can create. And my concern is less about, I'm against helicopter parenting, and I do think kids should be allowed to take some risk. And I was allowed to do the same as a child. It's almost the opposite in terms of like what loopholes this can create by saying, like, if a parent or a family, has certain values or beliefs, like they can do all these things. Like we can't possibly outlaw every potential negative thing that can happen to a child. And so I think it's really important to just have the ability for judges to look at the statute and have the discretion to determine whether harm is happening to the child. And I think just this paragraph 8 in here makes it clear that parents have the ability to allow their children to take reasonable risks to further their development as independent human beings. I completely agree with that line, and I do think it's important for kids to be independent and take those risks. I also just wanted to make an aside that I feel like there's been a trend in the committee lately to bring up transgender issues I know, I'm not blaming it, but I'm just saying, as the only trans person in this committee, it's just not a great feeling to have people try and make points by using my community as, just something to go back and forth about. It just doesn't make me feel good. And I just wanted to ask that people be respectful of that.
We will try and take that into account. Representative Murphy.
Thank you. And I wonder if maybe Representative Lynn could help me on the amendment. That proposed language. My question is it currently a violation of this section for parents to allow children to take reasonable risks? Is that? I mean, if we're going to,
I guess I would say no. I would think that. I hope that's what the law is now. But I guess what I was sort of saying is, it probably is a good idea to put that in statute to sort of have, to be able to have somebody be able to say, look, it's right in the law that you can do this. Even though it might be, you might read that by implication into the current law without this. I think there's a value to having it.
In other words, legislative intent.
Right, exactly.
And just follow up on
Yes.
that. Just on in terms of the word, what is your thought about the term reasonable? I know the chair raised a point earlier. Should there be a further descriptor of what is reasonable?
I would say no. I think that it's for example, in the self-defense statutes and stuff like that, it's pretty general language. You can use deadly force, or you can use non-deadly force if you have a reasonable belief. So reasonable is reasonable. The word reasonable or reasonableness is used quite a bit in this area.
Thank you.
So it's, in some cases, it's specific. In other words, let's say, would a similarly situated reasonable police officer do this? But in a broad sense of society, we just assume a reasonable human being. Is that what you're? Okay, so gotcha. Representative Sytek, and I see you.
First, I would thank Representative Lynn, because your opening remarks articulated what I was trying to say about the helicopter parents, and we may be micromanaging parenting to some extent. I sort of, I feel my sullenness has somewhat been lifted here because of that. I think the idea of number 8, Roman 8 by itself, while it is, somebody stole my line, I was going to say legislative intent, that this just sets a tone for how things are looked at judicially. You just have a sense that the legislature understands that your reasonable parents do reasonable things. And I would like to just see Section 8 as the bill, is my feeling.
Thank you, Mr. Chair. So what I was thinking, to kind of piggyback off of what Representative Murray was saying, is that I think that it would actually accomplish what we wanted to accomplish, the intent of what we want to accomplish, to have something that is like 8. And otherwise, what 7 does is it gets into more specific, and it creates more problematic, more problems where what Representative Murray was saying earlier is the idea that we all have kind of a specific situation in our head, right? And whether it's helicopter parenting or whether it's the opposite end of that spectrum, getting to, what is reasonable and what where we as a society say these are the parameters of what we think, what is acceptable and what is not in the best interest of the child. What we're really asking here is to make a statement of intent and say, we want this to be taken into consideration, which would also bring it back into line with the other legislation that we referenced without names, that, is really just saying, hey, this would be a good thing to consider when we're sentencing or deciding somebody's punishment.
Okay.
Yeah, I just want to ask a question, and it has to do with if you're trying to make it a more bipartisan bill. I was surprised by Section 2 of the law that says, in the prosecution of any person under this section, the tattooing or branding of any person or a child under the age of 18 constitutes endangering the welfare of such child. Would this now make tattooing people legal if you're...
No, because remember, if we were going to amend it and just leave Section 8, which says it's a violation, it's not a violation of this section for parents to allow children to take reasonable risks and for the development of their human beings. The previous part that's already clearly delineated in statute would trump that, in my opinion. Would you agree?
Thank you. Agree.
Yeah, thank you. Okay, with that, because we have a lot of work to do today, we're going to recess this until later on in the day, and we're going to come back to it then. With that, I open the executive session on House Bill 1038, and I recognize Representative Mannion for an amendment. Is that right? I read your...
Yes. So this bill, I make a motion to adopt amendment number, I believe it's 2024-0829H.
Seconded by Representative Murray.
Can you just repeat that amendment number, please?
Yes, it's 0829H.
Give everyone a second to get the amendment on it. Would you like to speak to your motion, Representative Mannion?
I would, yes, thank you. So we heard this bill last year. We had a subcommittee on it, and all the parties and all the parties involved came up with this amendment to the bill. It was reintroduced this year. However, it was reintroduced as the
Representative, we'll be taking a vote pretty quick.
We're in the voting mode.
Okay.
It was introduced as the original bill. So what this amendment is this is the amendment that we passed last year in committee. It also passed through the House. So for those reasons, I would suggest we adopt this amendment and ought to pass.
Thank you. Representative Murray, would you like to speak to your second?
I agree with my colleague.
Discussion. We passed this last year. I don't know. I don't recall what he said happened to it. Something about the other body, but I don't see any changes. Is there any discussion on it? Representative Muse?
One of the things that I wanted to say is what the amendment basically does is it puts the bill back into exactly the same thing that we sent over to the Senate that was interim studied last year. In a way, it kind of feels like expecting different results by doing the same thing all over again. But I did support the bill then. I was on the subcommittee. I'll support it again this time. But I do wish the sponsor might have done a little bit more to get the bill in better shape to actually survive the next step of the process.
It's my understanding the Senate that the sponsor spoke to people over there and they encouraged him to refile it. So it might be just one of those Lucy and the football things again. I do not know. We'll see. Representative Mannion.
Thank you, Mr. Chair. I also want to note that this has the longest sentence, if you remember, last year, in any bill that we filed, and it would be nice to get it into law.
Yes, I always strive for the Guinness Book in my legislation. Representative Murray.
Thank you, Mr. Chair. I was just going to add, from my recollection, the Senate interim studied it so they could see if similar laws had been passed in other states or if there was any federal law that was in conflict. And from what the sponsor said, there was no conflict found. Yeah, I do believe it will be passed by the Senate this time.
God bless you and your memory. With that, I would ask you to call the roll on the amendment. The motion is sought to pass on the amendment. The amendment number is 0829H as in hotel.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sitek? Representative Prue?
Yes.
Representative Janvrin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Lynn?
Yes. Sorry.
Representative Tenzar?
Yes.
Representative Harry Gathright?
Yes.
Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Selig?
Yes.
Representative Wheeler?
Yay.
Chairman Roy?
Chair votes yes.
20-0.
20-0. The amendment is adopted. I recognize Representative Mannion to make a motion.
Thank you, Mr. Chair. I make a motion ought to pass as amended.
Second.
Second.
Somebody? Seconded by Representative Prue. Would you like to speak to your motion?
Thank you, Mr. Chair. I think we covered it with my first speech.
Representative Prue?
Ditto.
Agreed. Anyone else want to say anything? Seeing none, I would ask the clerk to call the roll on the ought to pass as amended.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sitek? Representative Prue?
Yes.
Representative Janvrin?
Yes.
Representative Mannion? Representative Reed?
Yes.
Representative Stone? Or sorry, Representative Lynn?
Yes.
Representative Tenzar?
Yes.
Representative Harry Gathright? Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Selig?
Yes.
Representative Wheeler?
Yay.
Chairman Roy?
Chair votes yes.
20-0.
20-0 passes unanimously. Any objection to consent? Seeing none, it goes on the consent calendar. I hereby close the executive session. Okay. And well, I'm about to open the second one in about 2 minutes. If anyone in here is using their electronic devices to tweet or anything about that we're doing right now, please refrain. I've been pretty lax on the electronic device stuff, and I want to stay that way. So we had an agreement to not do that when we started this. So let's please continue that. We can talk about it after. With that, the next bill up. Hold on, I just got to wait for Representative Rhodes to come back with a pen and a paper. With that, I open the executive session on House Bill 1039 FN, and I recognize Representative Bolden for a motion.
I want to begin with a motion about to pass with amendment 2024-0852H as in House. And if that's not
Seconded.
palatable, I'm happy to withdraw and consider another motion.
Let's talk about it. Seconded?
Seconded.
Should be. Representative Salig, motion of adopting the amendment was by Officer Representative Bolden. Would you like to speak to your amendment?
Representative Bolden, can you just give me the amendment number?
Do we have it?
2024-0852H. So we had a very long bill. The amendment makes it a very short bill. The language was suggested to Representative Harriet Gathright by Representative Bob Lynn, who happens to be here today. He said that his suggested language is not necessarily an endorsement of the bill, just that he said that for the purpose of achieving the intended goal of the bill, that this language would fit. There was testimony from the county attorney's office that judges already have the ability to do what the bill was trying to accomplish. And Representative Lynn said in suggesting this language that it would make it absolutely clear that wiggle room is available to judges, that discretion is available to judges. So that makes sense to me, and it being my bill, I'm fine with this amendment. But if there's a lot of opposition, I'm open to another motion so that we can take some time over the summer to work on this. But at the same time, I think that also the supporters of the original legislation are satisfied at this point with this wording. And I don't expect any pushback from them. And as far as the concerns from the coalition, I anticipate that the brevity of this amended version, which would be the entirety of the bill, would satisfy their concerns as it relates to the long list of offenses that were in the original legislation and are now absent in the amendment.
Would you like to speak to your second?
Sorry, thank you. I fundamentally agree that it's important to just codify the importance of judges using discretion and considering all factors and ensuring that they do.
Thank you. And we're open for discussion. Representative Sytek.
I can't help but notice the echo to the direction that we went with 1012 or seem to be going with 1012.
Can I respond?
Sure.
I mean, unlike 1012, this just says the court may consider, not must consider. 1012 gives more, I think, explicit direction in the process of determining whether or not to charge someone. So the court may consider all facts and circumstances, which, you know, if we are in agreement that this just further clarifies an option that the courts already have, then if it is like 1012 in any way, we don't need that bill either.
Okay, I think let's talk about the substance of the bill now. Anyone else? Oh, Representative Murphy.
Thank you. I was part of the subcommittee that heard this bill. And as I had stated during those discussions, I was not in support of it as written. I do support the amendment. My concern had been prior that it didn't address vulnerable persons as the victim. And the number of carve-outs, I think it just sort of complicated things. Even though we've been told that the court already has this ability to have discretion, I think this is a good and more broad reminder. And I think that's the piece that I know those that testified had suggested, that even though the court had that discretion, they didn't feel it was always used. So I support this 1039 as amended.
Thank you. I too opposed the previous version for the various reasons that have been discussed, and I'm trying to find a reason why I should hate this one, but it's difficult. So it does seem to do what we said in the previous bill, insofar as it sets a legislative intent that we want you to look at this and take it into account. Even though they may already do so, it says just basically, while you're sentencing this person, keep in mind, to the extent you think it's relevant, that they do have other people to care about.
I think Representative Sitek had something more to say, or at least I should say, Representative Sitek, I'm not very good at reading lips. And that's why I was giving my attempt at baseball. Okay. And trouble understanding.
Representative Murray.
Thank you, Mr. Chair. Yeah, I guess I know we've talked about this, but I just want to reiterate the amendment just simplifies the bill, removes all the controversial material so that we are ensuring that judges are aware that they do have the discretion to take this information into consideration when they're creating a sentence. And I think whether we move forward with the amendment and attempt to pass the bill or interim study, we should continue studying this issue over the summer with all the advocates who have a vested interest in this. And I think the point Representative Sitek was trying to make was just that in the way that we simplified 1012 so we could all agree in it. I think that's what we're trying to do here. Okay.
Oh, thank you.
Further discussion.
Mr. Chair, I have a question.
Representative Rhodes.
I'm very confused because the bill that I have in all of my notes. So now is the amendment wiping out the bill and then just telling a judge that they may do something that they already are aware that they may do?
I believe it replaces the entire bill, and it calls to the attention of the court, similarly to what we just discussed in the previous bill, that the legislature wants them to consider this, even though they may already. It gives it a highlight, but I don't see any mandate that they have to, or that it says they should give preference to them over versus other convicted persons. So I don't see it being any different really than the previous one. But if someone else thinks that, I'd be happy to hear it. Representative Wheeler, hold on.
No, this isn't in direct response to your question, and actually, I might be about to say the same thing as I'm going to defer to Linda, actually, Representative Goff.
Representative Gath, right?
Yes. If you remember, we had testimony that this wasn't being used. Okay. We know that the judge has discretion, and this was brought about because it was not being used. So what we thought would be a good thing after talking to Representative Flynn, that we would look at just putting something in there as a remembrance that this should happen normally, but it's not being happening. And that's how the bill came before us.
Okay. As this is a significant change from what we had prepared to discuss and deal with today, I'm gonna recess this one to the same time as 10:12 this afternoon, and we will take these two bills up again at that point, and deal with it then. With that, I open the executive session on House Bill 1021, and I recognize Representative Mannion to make a motion.
Thank you, Mr. Chair. I make a motion to ITL.
Do I have a second? Seconded by Representative Selig. Would you like to speak to your motion, Representative Mannion?
I would, thank you. So this bill is covering a couple of different areas in our body worn camera law. One part of it is requiring the defendant to receive a physical copy of the body worn camera for defense. In May of this year, the Merrimack Superior Court ruled that that's what's to be done. So initially, the way the bill was written and the way body worn cameras were given out was just a link to it that they could watch. They couldn't have a hard copy of it. That case law changed that. So that's what we're doing now. Another part of this bill is that the defendant wants the ability to share these and display them as he sees fit. That could be on YouTube, or that could be anywhere else. And I'm strongly against that. Another part of it was exculpatory evidence not to be destroyed. It's not destroyed. I can tell you right now, anything that's an arrest is held for a minimum of 3 years. In most departments, and I know the ones I've worked for, it's 10 years for felonies. So it's automatically destroyed, providing that the case is completely disposed of. It requires a court order. We get thousands and thousands of videos a year. So to get a court order for every single one, every time the time is expired on it, would be a monumental task. So, and I don't think there's the time to do that. So most of what this bill is trying to accomplish is already being done.
Thank you. Representative Sedley, would you like to speak to your second?
Ditto.
Any further discussion? Representative Newman.
I just want to commend Representative Mannion for explaining our subcommittee in less than a minute.
That is admirable indeed. Further discussion? Seeing none, I would ask the clerk to call the roll. Motion on the floor is inexpedient to legislate.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sitek? Representative Pooh?
Yes.
Representative Janvrin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Lynn?
Yes.
Representative Tenzar?
Yes.
Representative Harry Gathright?
Yes.
Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Selig?
Yes.
Representative Wheeler?
Yay.
Chairman Roy?
Chair votes yes.
20-0.
20-0, the motion of inexpedient to legislate passes unanimously. Any objection to consent? Seeing none, will go on consent. Hereby close the executive session on House Bill 1021. I open the executive session on House Bill 1061, and I recognize Representative Tenzar for a motion.
Thank you, Mr. Chairman. I make a motion of ITL.
I'll second.
Second, Representative Harry Gathright. Would you like to speak to your motion, Representative Tenzar?
Yes, I would. Thank you, Mr. Chairman. This bill makes driving an uninspected motor vehicle a secondary offense in the state of New Hampshire. Currently, all of the violations of the rules of the road, inspection or registration are primary offenses, which means a police officer, deputy, or trooper can stop the vehicle. I have issues with this because it's going to be making a two-tiered system, which can gradually make law enforcement not able to do their jobs. The whole goal of law enforcement is to prevent the violation of the law and also to stop the violation of the law. For the record, I'm a retired trooper. Of the tens of thousands of vehicles I stopped, probably 1,000 or so were inspection violations. I'll let you know that I did not write much of any tickets on those. The whole goal was to let the person know, hey, by the way, you're uninspected. Get it fixed, whatever you need to do. I think that the sponsor also alluded to that this would be a pretext for a search. That's not going to happen. I just think this is a really bad bill and just opens up further problems with law enforcement helping to correct behaviors.
Thank you. Representative Harry Gathright, would you like to speak to you second?
Well said.
Thank you. I would also like to add that this claim of a pretextual for a search, you can stop a vehicle for just about anything. If you don't have probable cause to search, you're not searching. So just because you stopped it for a sticker versus a taillight versus anything, it doesn't help you get into search a vehicle. Having said that, often what you see on the outside of a body is indicative of what's going on inside your body. And when you see a sticker that's expired or whatever, sometimes it's indicative that the registration is also expired, that their license is has been suspended, and so on and so forth. So to say to our law enforcement, enforce these laws, this is what we want, but kind of don't enforce them, it sends a horrible message to law enforcement. So with that, Representative Mannion.
Thank you, Mr. Chair. And maybe Representative Lynn could, if I'm wrong, correct me on this. The Sterndale decision made your car almost as difficult as your home to search without a warrant. So with that being said, in my career, and I've been in law enforcement for 30 years, if I stop someone for a sticker, I'm probably not giving them a ticket, unless you're driving a brand new Mercedes-Benz and it's been 2 years and you just decided you weren't getting one. But maybe I'm just a big softy, so I didn't give out a lot of tickets for that.
Thank you. If I may inquire, in your experience, though, is it also not out of or unusual to find that the person may also not be registered and may also not have an active license, et cetera?
Yeah, that's been my experience. So you find other things with it.
Thank you. Did you want to say? Representative Murray.
Thank you, Mr. Chair. Well, first, I was wondering if I could ask my colleague. I was just curious what you meant by a two-tiered system. Is that in reference to like some violations being prosecuted or pulled over and some not?
So yes, this, thank you for the question. This would make the uninspected motor vehicle a secondary offense so that I would have to see another offense on top of that before I can even pull you over. And I just see that this could now be uninspected. Then next thing you know, it's registration and everything else. I just think the police should have the discretion to stop, to do their job the way that they should, and to not start micromanaging all of the violations of the statutes.
Thank you. Can I continue? Thank you. Thank you for your explanation. I guess the one thing I wanted to add is that I respect obviously all of your experience and what you've seen out in the field, but in my experience as a young person, most of the time when I didn't have my car inspected is because I didn't have the money to inspect it, and getting a ticket would have only made that situation worse. When I was in my early 20s, I would dread my birthday every year because I had to pay inspection and registration fees. And it just kind of like alarms me a little bit if people are going in with the assumption that like because their car is uninspected, then they must more than likely be guilty of other offenses. And I think because of that, I will be voting against the ITL motion, although, again, I do respect and understand the perspectives you're bringing to the table.
Thank you, Representative, and I do respect your opinion and view as a young person. I would, however, say that there are a great many of our criminal statutes that could possibly be caused by the fact that someone just doesn't have the money, and we can't, unfortunately. I guess I'd rather say we need to fix our economy more than we do our laws. So then you'd have more money to pay for your sticker. Representative Prue.
And I don't think that's what they said, is that they stopped them for an inspection sticker and were trying to look for more things wrong. They just appeared, right? But and to me, inspections are there for safety, right? That you have brakes so you can stop and all those things. So having your car not inspected can lead to more accidents, right? Because I see them from time to time where things don't work, or your car just stops in the middle of the road and somebody slams into you. So we need to keep our vehicles inspected.
Thank you, Representative Prue, and that's a really gets us really back to the point, and the point is that we have these stickers for safety, and it's about the safety of the motoring community. We kind of got sidetracked on I think it's Representative Linfall because he got us into all criminal justice-y stuff. Representative Rhodes.
Thank you, Mr. Chairman. So I'm trying to remember, and I have taken my notes on my little notepad here, I guess, or my bill. And I do remember when the sponsor was here and we were trying to ask him questions. There was a lot of questions that he wasn't able to answer. And along that path, it kind of came out that he didn't want cars to be inspected at all. And he even said that. He said, well, we've been trying for years to make inspection go away and it can't. So we thought this would at least be something to get started. That was his words. There was a question about, if your light comes on and you can't afford to find out what it is, you can't afford the mechanic. Pretty much every one of the large box auto parts stores now will tell you what is wrong with your car for free. I know for an example, because right now I have a light that I can't get off and my car is stalling at red lights. It's great. I was behind Representative Newell this morning and almost needed a ride here. That doesn't cost anything. And additionally, it is not an injustice to anybody to have to get your car inspected. You know all year that it's coming up. And, along with that, Representative Prue said it best. Like, what is the point? What is the purpose of an inspection? It's not to make anybody feel like it's a gotcha or to have to do something. Everybody has to do it. So, I think that we need to take that part into consideration.
Thank you. I think we've talked about stickers enough. I'd ask the clerk to call the roll. Motion on the floor is inexpedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Lynn,
Yes.
Representative Tenzar,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Unless you want to
Yes.
Representative Bolden,
Yes.
Representative Bradley,
No.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes no. Representative Newell,
Yes.
Representative Selig,
No.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
17-3.
17-3, I don't think I can go on consent, can it? I think it can. Does anyone object to consent? All right, we're going to try and put it on consent. With that, I close the executive session.
What was the
17-3. I open the executive session on House Bill 1097 and recognize, I think you were 1197, Representative Muse, were you going to make this motion?
Yeah, I was gonna let him do it.
For which bill?
1097
Is it 1197?
or 1190? No, it's
I was going to make a motion to ITL.
1097?
Oh, no, 240 conversations.
1097.
Oh, maybe you meant
wait a minute,
1197 or
Yeah,
1197.
1097. I got ahead of myself with
Yeah.
the 97s. With Representative, with Bill number 1097, I recognize myself for a motion of inexpedient to legislate. Can I get a second? Seconded by Representative Rhodes. I'll speak to my motion. This is, again, going back to the question of, do we want our conversations recorded without both people knowing there's a recording? There's been, it's kind of like the ocean tides. It comes in, comes out. However, speaking for myself, I do not feel comfortable with the idea that I can at any point be having a conversation with someone personally that I think is private and personal, and all the while it being recorded, and then later on in the afternoon it's on the internet, and it's just it's a creepy feeling. We have said that we want our privacy. We've even put it in the Constitution. I just think that this is a violation of privacy, and it also starts getting into questions about what's domestic issues, people setting people up, picking fights with someone and then turning it on a recorder after the other person's up here and only recording that portion of it. It's just, I don't think any good comes from it. Representative Rhodes, you want to speak to your second?
No, thank you.
Anyone else? Discussion? Representative Sitek?
Yeah, I'll be opposed to that because we're trying to stop technology. I can have a pen in my pocket that records. It's my right to privacy. You can't search me to tell me I can't use my pen. What should be done with this is it should be said that you cannot use that recording for any legal purpose. That would be the step I would be willing to take. That you can take it. You can, like one time I listened to an accountant doing a lot of technical things, and I wanted to mull that over. So I didn't want to be taking notes. I'm trying to concentrate on what he's saying. So I let the machine take the notes. He didn't like it.
And that's the point. You should ask, hey, do you mind if I record this so that later on I can do it? And if he says, I do not want you to record me, thank you very much, you may not do so. Any other further discussion? Seeing none, the motion on the floor is inexpedient to legislate. I'll ask the clerk to call the roll.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Lynn,
Yes.
Representative Tenzar,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Selig,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
19-1.
Representative Sitek, do you object to consent? The bill will go on consent. 11-1, motion carries. Close the executive session. Oh, excuse me, 19-1. Yeah, something like that. With that, I open the executive session on House Bill 1197 and recognize Representative Muse to make a motion.
Thank you, Mr. Chair. I would like to move, let me see, amendment number Amendment number 2024-0597H, and move ought to pass with amendment.
Second.
Representative Muse, would you like to speak to your motion?
Yes, thank you. This is a bill that was introduced by Representative Munns, and what it would essentially do is authorize additional state agencies to take fingerprints of people who are undergoing non-criminal background checks. So one of the things that came up during COVID is the system that actually does that, that's operated by the Department of Safety, was very, very much overtaxed. So part of what this bill is about is if we ever run into a situation like that again, it's being able to take the burden off of the Department of Safety so we don't put a burden on to employers and state departments and other folks who basically need to pass these background checks to make sure that people they're hiring don't have criminal records and things of that nature. So what the amendment essentially does is a couple of things. Perhaps the biggest thing that the amendment does is it changes the effective date, which was one of the biggest objections that the Department of Health and Human Services had. They were concerned potentially about some of the cost. And so by moving the effective date outwards, one of the things that does is it puts us outside the current budget cycle. It also allows the task force that would be created to look at the implementation of the bill. It actually gives them time to figure out things like how many machines are needed, where are the best places to deploy them, how exactly are they going to be deployed, and to get a better idea what the potential cost of doing something like that would be. So essentially, the bill was supported by the Department of Safety. They think that this is going to take part of the burden off of them, and I urge you pass it.
Thank you. Representative Saley, would you like to speak to your second?
Thank you. I agree.
As do I. Further discussion? Seeing none, I'd ask the clerk to call the roll. Motion is to adopt the amendment.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed, Representative Lynn,
Yes.
Representative Tenzar,
Yes.
Representative Harry Gathright, Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Selig,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
20-0.
20-0, the amendment is adopted. Representative Muse, would you like to make a motion?
Yes, I move HB 1197 ought to pass with amendment.
Seconded by Representative Harriet Gathright. Would you like to speak to your motion, Representative Muse?
I think I spoke to it effectively in the amendment.
Representative Harriet Gathright? Further discussion? Seeing none, the motion is ought to pass with amendment. I would ask the clerk to call the roll.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Lynn,
Yes.
Representative Tenzar,
Yes.
Representative Harry Gathright, Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Selig,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
20-0.
20-0. Any objection to consent? Motion carries. Beyond the consent calendar, I close the executive session. We are going to take a 10-minute break, and we'll be right back. I'm going to reopen. Hello? 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 I'm going to reopen the executive session on, what is that bill? On House Bill 1039, and Representative Bolden wanted to make a,
I'd like to withdraw my, to pass this amended motion and make a motion of interim study.
who seconded that? Would you withdraw your motion? Okay. Is there a second on the motion of interim study? Seconded by Representative Wheeler. Would you like to speak to your motion, Representative Bolden?
The stakeholders are in agreement with interim study.
Good enough for me. Further discussion? Seeing none, the motion on the floor is interim study on House Bill 1039. And I would ask the clerk to call the roll.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek, Representative Prue,
Yes, please.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Lynn,
Yes.
Representative Tenzar,
Yes.
Representative Harry Gathright, Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Selig,
Yep.
Representative Wheeler, Chairman Roy,
Chair votes yes.
20-0.
20-0, motion carries in expedient, interim study. And the bill number, oh, okay. Actually, any objection to consent? None. It'll go on consent. Executive session is closed. I'm going to reopen the executive session on, where is it? No, the trespass bill. That's what I'm looking for. Yes, 1204.
Does anybody have the amendment for House Bill 1204, the one that we just heard on Wednesday about?
Jim Spillane's name's on it. Okay, I open the executive session again on House Bill 1204, and I'm going to offer amendment number 0839H. Can I get a second? Second, Representative Rhodes. This was a technical change as requested. I believe who requested that he change this? Yeah. Maybe. It was making it the bill more fit better with the current statutes. It's a statutory placement amendment. The bill still is pretty much the same. This bill would make it so that law enforcement, if they were going to enter on your property that has no trespassing signs, they have to honor the no trespassing signs, and they have to get a warrant if they need to. It still exempts fish and game. They can go on the property. It exempts exigent circumstances if there's an emergency where evidence could be destroyed or removed. I'm trying to think of all the possible exigent circumstances. Fish and game issues are for example, if you wound an animal and it runs onto the property, you can still get it. Basically, it's an answer to the age-old, as we heard in testimony, open fields doctrine, where the U.S. Supreme Court has said that if it's not part of the curtilage, which is immediately surrounding your house that you use every day, law enforcement can go wherever they like on your property and do whatever they want. We heard examples of cameras being placed. The sponsor sent me several. I challenged him, and he met the challenge. He sent me 3 different cases that have in New Hampshire jurisprudence where they have cited the open fields doctrine and allowed police to do this. I have spoken with Representative Lynn. He said he's unaware of it, so that means the cases are older. But the fact that they're old doesn't matter. That means they haven't been overturned. So theoretically, the open field doctrine still applies in New Hampshire. This would, as I said, require law enforcement to do the same thing they would have to do with your house, with your property, unless there were the exceptions that are already in the bill, such as exigent circumstances and such. They have to get a search warrant. Would you like to speak to your second, Representative Rhodes?
No, thank you.
Discussion. Representative Newman.
I would just like some help. I would just like some help with the wording of the amendment to find out where I start to compare the various things that have been changed and no longer changed, and it's got several laws in here.
Sure. Let's get the original bill, please. Representative Murray.
Thank you, Mr. Chair. From what I can remember, I believe that this is removing the references to the body camera statute.
Yes, that's it. Thank you again for your memory. The body camera statute is already covered in statute. If you recall, the original bill said that they had to have their body cameras on whenever they went on the property. And that conflicted with the law we already recently passed regarding body cameras. So that's what the amendment does. It removes references to body cameras.
Thank you.
Thank you. Yep, exactly.
What's the rest of this going? Renumbering?
Yep. Representative Wheeler.
Thank you, Mr. Chairman. I'm going to be voting ought to pass on this bill. I think, if it's your property and you have it posted, that the state should not be able to wander on that property. And the open fields doctrine seems silly to me. If it's not posted, then the police have the ability to go onto the property. That seems appropriate and consistent with New Hampshire law. And I think that if it is posted, the police, because you have posted it, should have to listen to that posting and contact you and get permission to go on your property or get a search warrant if needed. So I'll be voting for the ought to pass on this.
Yeah. I'd like to kind of address the hunting issue because we discussed in a previous bill about hunting, and this kind of references, again, your personal property. Our trespass laws in New Hampshire are pretty detailed, and that's for good reason. You can post your property, no trespassing, that means nothing. You can post your property, no hunting. That means you can still go hiking, walking. The police would still be able to walk through there. But if hunters cannot go on there. So you could post your property, no ATVs. You can post it any way you want and be very specific in how you do so. And that is what would trigger the trespass part. But if you put no trespassing, that means nobody, nothing, zero, including the police, unless they have a warrant. So I think that kind of covers that. Representative Salik.
Thank you. I just had a question. One of the people who testified was John Jurgen.
Did you say Jingleheimer Schmidt?
Maybe. I don't know. I can't read my own handwriting here. But from the State Department of Labor, who raised concerns about the broadness of all government agents, which I don't believe is covered through your amendment, but he referenced that it would make it difficult in terms of enforcing inspections related to different things like labor laws or conditions in workplaces. And I don't see that addressed at all.
If you recall, I questioned him about that, and he admitted that really no, because this really applies to single family homes, and they don't do labor laws in single family homes. That's about businesses. In a business, if they want to enforce labor laws in a business, they're going to go into the building, which is curtilage anyway, which isn't impacted by this. This is about the open fields doctrine. So unless the labor department is going out in the woods behind my house, doing something to somebody's doing labor out there, which I can't even imagine the scenario. I think that they were just being overly cautious. I can't, if anyone can think of a scenario where the labor department would need to be in the woods behind your house.
If you have an elevator in the woods, maybe?
Yeah, you could have a woods elevator. But beyond that, their duties generally 99% of the time are going to be with industrial properties and things of that nature. So once you had admitted that really they were just kind of doing a belt and suspenders, I didn't see the need to address that. Representative Chambers.
Thank you, Mr. Chairman. I'm kind of at a loss here. I wasn't here for the public hearing, but I will say this. I am actually a member of a planning board, and the planning board has very large latitude in inspection. This would appear that it would apply to members of the planning board, conservation commission, zoning board, et cetera, whereas the statute dealing with those boards give them the right to inspect at any time without a warrant. This is now telling them they have to go get an administrative inspection warrant, which I think is contrary to what I believe we want.
Already, well, first of all, they can get landowner permission to go look at whatever on their property, but I don't see where any government agency, I don't care if it's the planning board, whoever, should be on my property without my permission. And if there's a statute that says that they're allowed to traipse around my property, frankly, I find that offensive. I think that it's my property, and if I post it, no trespassing, I mean no trespassing, not no trespassing, except for people who want to come look at it for planning purposes. You know, we may disagree on that, but that's my, again, we heard from the trooper, it's your home's your castle. It's my castle. Contrary to what the trooper said, though, I did find cases where the New Hampshire police have done just that. So he also, when I asked him why, if they're already doing it, why would it hurt to pass a statute? And we really didn't get a good answer for that. And with regard to that, I didn't see anyone from the municipal association here to testify against it. And generally, if there's an issue with it, they would be out against it. And we didn't have any contrary testimony. Representative Newman.
I'd just like to understand where it says in here that it only applies to single-family homes.
It doesn't. But we're talking about, okay, let's think about the labor department, right? They're going to not be inspecting in the woods. They're going to be inspecting within the curtilage of a building, right? So it doesn't say single-family homes, but where in the world would the labor department?
I'm just to single-family homes is all.
Oh, no,
That's all I
specifically
want.
no,
I don't want to
but-
go back to the labor department.
Okay.
I just wanted to
It
know
doesn't
where
say
was.
single-family homes, so the labor department's concerns, again, would only apply to within the curtilage of a building anyway. Representative Newell.
So I remember that part of the conversation. I remember that the person who is a representative of the Labor Department was the person to come here, but that it may apply to a variety of other people who could be considered a government agent, which I think would probably include the Planning Commission. But the way that I read this, it also says, it says notwithstanding any other provision of law. So I think if there, are provisions that allow for the Planning Department or, inspections and things like that, that would be allowed. And then also, upon entering private land, a government agent shall immediately notify landowner, lessee, or occupant if notice can reasonably be made. And so it does allow for a little bit of breathing room, but it's also extending the same rights as your home to your property.
Thank you, Representative Newell. I like your explanation much better than mine. To Representative Chambers' point, if there's a statute that says the planning board can go on property, this is notwithstanding, so they can do it. And that would also apply to assessors and anyone else who in statute already has the authority to go onto property for whatever government business. This wouldn't apply to them. They are exempted because of another statute. And frankly, we could write other statutes in the future and they would trump this because it says other statutes notwithstanding. So further discussion. Representative Pierre Gathright.
Okay, so why were you removing 5? I would believe that you would want that in your document.
Representative Mannion, please.
Thank you, Mr. Chair. So that's already in statute. So to add, it's already in the body camera statute that anytime you're performing a law enforcement function, it shall be recorded. So to have it in every other statute If you add it to investigations or murder, whatever kind of other, you can't add body cameras to every statute. There's a statute governing it already. So there's no need to double up on it. So because it's removed doesn't mean it's not happening. It just means it's already covered somewhere else.
In other words, the statute that specifically covers body cameras already requires them to turn them on when they're performing law enforcement functions. So it would be redundant to have it in here, because then we might as well put body cameras in every statute that the police are involved with. Instead of do that, we put it in one body camera statute. Is that right, Representative Mannion?
You did better than I did.
Thank you.
Thank you. Representative Muse.
I think what we have here is your classic bill in search of a problem. The person who gave the most testimony at a public hearing was from an out-of-state advocacy organization who basically admitted to the fact that he's made passing bills like this his life's work in other states. We didn't hear from a single property owner who was aggrieved in a situation like this. We also heard from police officers that essentially police officers in New Hampshire are actually trained to respect other people's property. When they see that property is posted, they contact the property owner. I think bills like this are always interesting as intellectual exercises. But the fact is, with 19 bills on the calendar today, I think it's important that we focus on the ones that actually are going to solve problems. And I'm just not sure that I see a problem here that needs to be solved. Thank you.
Thank you. I would say that the vast majority of lobbyists we see are either connected to or part of an out-of-state quote-unquote organization, and they often write legislation for legislators. So I will not use that to detract from any bill that's before us. With regard to not hearing from property owners, one, I believe several other people in here are one, and I don't want them on my property. And whether or not it's happening, I guess we don't leave it to the police to Boy Scout swear that they're going to do things that we think they should. That's why we have the Constitution, and to keep them in line. And we also have numerous laws that limit what they can do. So I did find cases where it's happening, and sometimes it may not be happening every day, but we do a lot of prophylactic bills. And I think that this is one of them, but we agree to disagree. Any further discussion?
Yep.
Representative Harry Gathright.
Just looking at some of my notes from that day, and I think it was Chief Welch from Rye that testified.
Yes.
And he also talked about, they believe that the home is our castle, and the training at the academy. When in doubt, get a warrant. He also mentioned that the warrants is standard in most cases. They get yearly and updated training, and they actually were working on the state certification, which would say that they would have to have warrants in some cases when entering a property.
Yeah.
So if this is already, I guess, codified in their training at the academy, I would just want to know, why do we need that bill?
Representative Wheeler.
Mr. Chairman, I hear the points made by Representative Gothright and Representative Muse about training and how the police are already trained to protect property rights. I made the same point to Chief Walsh when he was here, and he didn't satisfactorily answer my question. I said, well, you're doing a great job in Rye right now. You've got a great chief there. We've got Director Skippa. He's doing a great job training. What's to say 10, 20 years down the line, there is less of a great director of police standards and training, or less of a great chief of police in Rye. That person might not train their officers to respect property rights as much, and legislation, statute like this would make it so that it's codified into law by the legislature that people have a right to their property. If it's posted, then people can't go on it, whether it's the state, whether it's hunters, whether it's anybody. If it says no trespassing, then people cannot trespass. And I guess I just have to make the point, because we hear it all the time in this committee, we cannot rely on the training standards of an administrative agency. You know, whether it's the racial profiling bill or anything else, we hear all the time that it's codified into training, but it's not happening. And I think it's important sometimes for the legislature to take action to codify some administrative action for that agency. And that's what this does.
Thank you. Representative Mannion, are you good? Representative Newman.
Yeah, I have a problem with this law. I feel that we already have a Supreme Court decision that says you're in an open field, a big, large area away from any residence or whatever you're talking about. That this bill requires that you could get the consent all the time, and it's section 4. It says, unless entering on the land pursuant to the consent or exigent circumstances, a government agent shall show the search warrant authorizing entry into the property owner. And it starts to use the word, instead of secured premises, it uses private land, and it doesn't have a definition for private land. So I assume that means any land that landowner was. So I think it's too broad. I think it violates an already existing U.S. constitutional law that says that you have no right to privacy in an open field. So I'm going to vote against this law. Thank you.
Thank you. For clarification on open field, the open field is kind of a catch-all word. It doesn't necessarily mean what you picture as, you know, the fields of barley. It's not that. It just means the property that is not the curtilage. So I own 6 acres, and I got a pool, and probably 20 feet beyond that, it's no longer the curtilage. When I'm mowing it, sometimes it feels like an open field, but it's just my lawn. And beyond that's a couple acres of woods. Also not an open field, but that's considered the open field. So it's not a constitutional law, it's interpretation of the Constitution. And we can't stop federal agents with this law. They can ignore it and they can say open fields until there's a federal law. But our state law enforcement officers would have to honor this and not go into my open fields. But your point is well taken, and we agree to disagree. Representative Pratt.
Well, I'm a landowner, and I'm also in favor of this law. Anybody that wants to leave their property open for everybody to walk on just doesn't have to put the signs up. All this does is it makes it clearer that if you put a no trespassing sign up, no means no. No trespassing means no trespassing. That's all this bill does. If you don't want that to happen, if you want people to be able to walk across your property anytime they want, you just don't put the signs up. Simple as that.
Thank you. I would assume that you could even post your property no law enforcement if that's what you wanted to post it. We are very, like I said, our no trespassing laws are very complicated. With that, I would ask the clerk to call the roll. The motion on the floor is ought to pass with amendment. No, I'm sorry, this is the amendment. The motion is to adopt the amendment.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sytek? Representative Prue?
Yes.
Representative Janvrin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Lynn?
Yes.
Representative Tenzar?
Yes.
Representative Harry Gathright?
Yes.
Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Reluctantly, it does improve the bill. Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Selleck?
Yes.
Representative Wheeler?
Yay.
Chairman Roy?
Chair votes yes.
20-0.
20-0, the amendment is adopted. I make a motion of ought to pass with amendment.
Second.
Seconded by Representative Rhodes. Unless anyone has anything significant to add, I think we pretty much discussed the whole thing. Seeing none, I would ask the clerk to call the roll. The motion is ought to pass with amendment.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sytek? Representative Prue?
Yes.
Representative Janvrin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Lynn?
Yes.
Representative Tenzar?
Yes.
Representative Harry Gathright?
No.
Representative Muse?
No.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
No.
Representative Newman?
No.
The clerk votes yes. Representative Newell?
Yes.
Representative Selleck?
No.
Representative Wheeler?
Yay.
Chairman Roy?
Chair votes yes.
15.5.
15.5, this will not go on consent. I'll address this after, but I'll say it now too. We're all off next week, but I need the reports, be it pro or against, no later than Tuesday, because I have to go into the clerk's office by Wednesday. With that, I close the executive session, and we will meet back here at 1:15. We are on lunch for 1 hour. I'm opening the executive session on House Bill 1214, and I recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I make a motion to ITL House Bill 1214.
Is there a second? Representative Prue? Oh, would you like to speak to your motion, Representative Rhodes?
Sure. So I do recognize I think I do understand the intention of the sponsor with this bill. There are already restorative justice programs in the state. I know for a fact I am on one for the county. They actually work quite well. Basically, if a minor commits a crime, they have the option the judge can say, hey, look, we're going to have you go this path, kind of try to right your wrong. And then when the program is complete, the charges are never filed. They disappear. I was a little bit confused because there already is something in existence. I was a little bit confused on the whole purpose of this. But I also think that, you have the option to go meet with your district attorney's office. You can meet with your local police departments. I just don't think we have to have a law that gives you the right to do that, because everything that is wanted to be done can already be done without a law to do it.
Representative Prue, would you like to speak to your second?
No, I think she covered that quite well.
Yeah.
Thank you.
Okay, I just like to start right. I do want to point out that it's not only restorative justice, but it was the hate crimes portion that the sponsor, and I'm sure she's going to tell us, was interested in. The reason, and probably the majority, if not the entire reason that I'm not in favor of this, it isn't anything to do so much with the subject matter as we've heard from the speaker and the clerk about these committees and commissions, and we have so many of them that are, because once we do this, it's on the law forever. The committee or commission will expire, obviously, because it's a committee. They only have till September to come up with some kind of report. But the marching orders we've kind of gotten is, unless it's absolutely necessary, if it can't be done some other way, we shouldn't be doing new committees or commissions. I feel like this is an important topic with regard to the hate crimes in juveniles. A lot of them are getting caught up in this, but I don't feel we need to codify it. And I think we can do a lot of work on it on ourselves. We can figure stuff out and come up with ideas without putting in statute. Again, though, that's just one person's opinion, and I'm going to open it for discussion. And I know, without even looking up, Representative Salig wants to talk. Oh, sure. Okay. Sure. Yeah, come up. Yeah. Representative Newell, and I saw you out of the corner of my eye, Representative Muse.
Thank you. I think, point well taken, I guess, about the committees and commissions and things like that. What it really comes down to, I guess, is how you prioritize it, right? And what you think is really important. I do understand, especially because we are in the same county, that this is happening in our county. One thing that I have heard about the success in our school system and in our county and things like that, is that it has been helpful. And I think that, what we do here is not just for our own counties, although we do that as well. But, we try to say, hey, this is working really well in this county. Maybe we can take that information. We can, see what's happening in other counties and really come up with something that is helpful on a state level. So I feel like this is still very much worth doing. Even if we are busy, I think we should make it a priority. So,
Thank you. Further discussion. Representative Wheeler.
Thank you, Mr. Chairman. I'm going to be voting against the ITL motion. I appreciate the clerk's position on committees and study committees and things like that. This is, I feel, is an important committee to move forward in, and I'm sure, knowing how passionately Representative Selig feels about this and how passionately other representatives feel, that there would be membership for this committee. So I'm going to support this. I think that even if it fails, though, that there would be a way to move forward with one of the existing commissions or committees that exist already are given statutory charge from us, to have them look at best practices for juveniles getting these charges and going into juvenile prison. I'm saying that even if this bill fails or comes out 10-10, which it seems like it might, that there, I think, is a consensus that there might be a good, it could be a good impetus to move forward to start looking at how we can deal with this issue, which seems to be one.
Thank you. Good points. Representative Muse.
Yeah, so we're at a point where hate crimes are basically on the rise in New Hampshire, and unfortunately, a fair number of the people who are being apprehended for those crimes, when they are apprehended, are juveniles. And I think one of the things that we try to do in our criminal justice system is to put young people like that into a position where they can more effectively begin to make decisions and do things that can kind of turn their lives around. And I think we've all read instances of people who were involved with hate groups when they were young and had different experiences and wound up feeling a different way. To me, if we didn't have the state attorney general's office, just recently beefing up its hate crime division, if we didn't actually have an issue in New Hampshire with it, I think I'd agree with you. I'm not a big fan of creating study committees for the sake of creating study committees. But this is an example of where, an area where I think people who have a little bit of experience with the law, and I would consider most of us as having a little bit of experience, can draw on people with a lot more experience and maybe come up with some solutions that could put us in a better place. That's why I like the bill when Representative Selig put it forward, and why I support it.
Thank you. Representative Selig, and could you explain, I know we've already gone over it, just explain what the committee would do.
Thank you. So my motivation for the committee is really the combination of, I think, being a former teacher and teaching high school level students, being a parent of teenagers, and knowing how easy it is for teenagers to be swayed by their peers to make poor choices at times, choices that in moments of better thinking and being their best selves, they wouldn't choose to make. But sometimes those impulsive actions have really serious consequences. And I was thinking about that a lot over the summer, at the same time as there were a number of hate crimes increasing across the state, as well as within my own child's high school. There were a number of significant incidents, instances. Getting my S's out is getting trickier. So thinking about all of those things, and then at the same time, I was reading about the success of the teen court programs in Maryland, which are not restorative justice programs designed by adults for teens, but programs designed by teens for teens, where they were ultimately coming up with models that were had a 94% success rate in many cases. So very, very few kids were ending up coming back into needing additional situations, and thinking, was there a way to put together something like the teen court program, which no longer exists in New Hampshire, and trying to figure out why it doesn't exist. Is it a matter of we don't have the resources for it, or is it a matter of truly it doesn't work here? And nobody could answer that for me when I made those initial calls. So trying to figure that out. We have, in some counties, we have youth diversion programs, but not in every county. In some districts we do, in others we don't. So trying to think about, okay, we've got all these disparate pieces. How can we put it all together to make sense out of it in a way? Because my ultimate goal is not to have kids end up in the judicial system at all, but to help them learn why it is they're doing what they're doing, so that they'll make better choices in the future, and ideally break the cycle, right? Break it completely, so that rather than someone going into, say, a juvenile detention center and then aligning themselves with people with misguided, hateful ideas, and coming out of that and being more likely to end up in the adult judicial system, that we get them out of it completely. And maybe the next time their friends say, hey, let's go do this really stupid act, they're like, no, we shouldn't do that. Let me tell you what I learned. You really should, we don't want to do that. So that's where my motivation came from. But trying to figure out how to put all those pieces together into something meaningful. There were so many different partners I spoke to, and they're like, oh, it's a great idea. You could try this, or you could try this. And so just trying to bring people together so we could make something sensible out of it at the same time.
Who's on your committee?
Who's on my, who
Yeah,
did
on
I
the bill.
speak to?
Yeah. Who
Oh.
would be on it in the bill?
I don't have the copy in front of me. I'm sorry. I'm all disassembled here. So, Representative Alicia Gregg from Hillsborough County, I reached out to. I spoke to, obviously.
No.
Oh.
I mean, who
Three
would
members
who?
of the House,
Oh, who is the makeup of the
appointed by the
committee?
Speaker.
It's a total of,
one member of the Senate. appointed
three
by the
members of the
President.
House of Representatives and one member of the Senate. And then the other
Any
partners.
outside people appointed to it, or just
No, because it's a study committee, so you can't
right?
require them. I did have a long conversation with Sean Locke from the Attorney General's office. And when he first called me, he was very skeptical of my bringing this forward. And at the end, he said it was a conversation he'd like to be part of. And he would want his office to get involved in that. We've had some additional conversations. And then right before we went to hearing on this, his department went from him to like 4 people. And so I didn't hear back from him because I'm pretty sure he was trying to figure out how to supervise his 3 new people and grow his newly growing department. I also spoke to Tom Velarde, who's now in the Attorney General's office. He was very involved in creating restorative justice programs in Stratford County before he moved to the state's attorney's office. So, and with the ACLU as well and their support. And I spoke to someone from restorative justice. I just don't have their name at the top of my head.
And do you feel like you could accomplish what you want to accomplish in 3 months?
I feel like we could accomplish a lot. We might not accomplish everything, but we might be able to come up with some answers in some ways that would be meaningful.
Representative Bolden. Oh, excuse me. No, Representative Muse. Did you have your hand up, or did you already speak? You already spoke. Representative Bolden.
So it sounds like instead of deciding on your own as a lawmaker how to solve this problem, you're just suggesting that time be spent by a committee of people figuring out how to solve this problem. I respect that. I think it's refreshing for a New Hampshire state representative to not think they have all the answers.
Yeah, my
I don't know.
idea
I
would
was
be
thinking about changing my vote until she said that. So.
Oh, I mean, my idea is really to look at what's best practices for all kids, that it's not a partisan issue. It's really an issue just of how do we figure out something that's going to best serve the kids across the state. And hopefully also, if we can avoid having them end up in any form of the judicial system, save us all a heck of a lot of money.
Representative Reed.
Thank you, Mr. Chairman. This peer-led group, where would this take place? Would it be at the Department of Corrections? Would it be at a school? Would it be at a community center? Where do you envision this taking place?
That's a great question, and why I need a study committee. So we can look at all the different possibilities and what would actually work for some of these things. I don't even know if it would still work in the state. I know it's working in other states. And so, again, there was one in Merrimack, but there wasn't in any other part of the state. And I don't know, they said it disbanded in part because of the pandemic, and whether it couldn't be restarted or whether it's just that there's not the funds. I don't know the answers, and the people I reached out to weren't able to give them to me at that point.
Follow up.
I think it's a great idea. I just would not want to see it with everything going on in schools right now. I would like to see something like that in a different setting so that they can focus on academics, get more back on track in the schools. So what they learn, that the committee should be extracurricular.
Right. This wouldn't be a school-based thing. This would be a study committee to figure out how to deal with these issues. And if you would like to be on the study committee, I'm sure that can be arranged with the speaker with your support.
All right. So, given the discussion, I'm inclined to change my position. So I'm going to tell my members, you can vote however you want. If you're inclined to support, I would entertain removal of the ITL motion just to save us from doing 2 different votes. If you wish to move forward, that's obviously your right, and we can have that vote too. Who made the motion?
I didn't. May
Oh,
I say one thing?
sure, absolutely.
So, if I may, this is to Representative Selig. so what I was trying to say is that the restorative justice program and just the in general, I guess if I want to say the redirection program that we have at the county level, you would probably be welcome to join us for one of those. And I think it would probably answer a lot of the questions you have and maybe help with the direction that you're trying to go. So that's kind of what I was getting at, is that a lot of what you're trying to accomplish could be answered with that without necessarily having to have it put into law. That's what I was trying to get at. It might answer a lot of the questions that you have. So that was that.
Representative Seitek.
I want very much to be wrong. I want this to work, but I don't believe it. I would like to see the results, because I see these life's cadavers walking the hallways, and I don't know how you reach them. If I ask them for a pass, I'm going to get a fight. And for every legislator I see who's recovered from drugs and has come back and leading a wonderful life, and I'm not, I shouldn't have used wonderful life. There are many who, I don't know the numbers, who've committed suicide, who've lost their lives. And to pivot this on the fact that we may rescue a precious few, I want to be wrong, but I just don't. If I get outvoted, that's great. I want to lose. I want you to succeed, but I don't. I guess I'm a little bit jaundiced. I don't think we approach this, and I'll finish with this, from the mentality of rational adults who know best, who would not. You don't even think about littering. Okay, how do you can transmit those values to somebody who's who traffics in hate crimes, who has absolutely no interest in society? I realize I'm sort of more jaundiced than I should be, but that's my life's experience and how I'm approaching this. Thank you.
Thank you, Representative Seitek, and we are greatly concerned about your liver. Representative Selig.
So, again, I'm not thinking I'm going to solve everything with this. There are going to be the people like our friend who likes to send us letters on a regular basis who are going to continue to be full of hate for anyone who isn't just like he is. But with kids, more times than not, it's because they've gone down a rabbit hole. And if you can get them the right ladder to get them back out of that rabbit hole, you can avoid a lot of problems. And if we can catch them early and identify things. And so again, the goal of this is really to look at what do we have that is working. And I hope we have more programs working than it appears from where I sit. But what's working, what can we be doing better? And what are the other options? So maybe there are other things, but again, my goal is in having a study group is to bring together constituents from different angles to try to figure that out collaboratively, so that maybe you'll be put out of business as a bail commissioner, and at least in relation to this crime.
Okay, now you're getting crazy. You had me until you went off the rails there. All right, so
There's a bunch of hands up here.
Representative Newman, don't snatch victory from the mouth of.
No, I'm just thinking, I never try to snatch victory, but I don't. A lot of times I get too many defeats. I just think that this is a good thing. We've been to drug court, and we saw how much they thought that was a valuable thing to do because it kept somebody out of the criminal justice system. And I'd like to see that accomplished. And this might be the opportunity to take a little bit of effort that might get us to understand whether or not we could do that with this. This doesn't make a law. I mean, it's something I think we should follow.
I agree. I mean, it doesn't cost anything but time. And just to be clear, before anyone makes any or removes any motions, anyone who worked on the bail last summer is probably not going to want to be on this. I'm going hunting. I don't care what study committee. I'm not being part of it. So, Representative Rhodes, would you entertain withdrawing your motion?
I will withdraw it, hoping that somebody else makes it and writes the report.
Who made the second?
That would be me, and I will withdraw my second.
Okay. So I recognize Representative Salig for a motion.
I move OTP for 1214.
Seconded by Representative Wheeler. We've had discussion. It is what it is, and you're either for it or against it. Vote how you want, and I would ask the clerk to call the roll. And one more time, I'm not going to be on the study committee.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sytek,
You can say yes, you know.
Representative Prue,
Yes.
Representative Janvrin,
No.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Lynn,
Yes.
Representative Tenzar,
Yes.
Representative Harriet Gathright, Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Selig,
Absolutely.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
18-2.
18-2. Is there an objection to consent? Seeing none, I hereby close the executive session,
Thank you.
and you're welcome.
Send you the bill in the morning.
Yeah. And with that, we move on to, No one objects. It goes on consent. Relative to protective custody, I hereby open executive session on House Bill 1270.
Guys,
1270, and I recognize Representative Janvrin for a motion. What?
Yeah, Mr. Chairman, I defer to the person that has the amendment for the bill to make a motion.
Who has the motion, the amendment? Oh, it's you. Okay. Recognize Representative Newell.
Hello. Trying to pull it up since the amendment changes things a little bit. Okay, so the amendment is 2024-0851. And the reason for the amendment, let me just talk a little bit about kind of what the reason for the bill was in the first place. The reason for the bill was because people who were being brought in under protective custody there was some lack of resources at the end of the day, right? So there were not the resources to be able to satisfy the law in the way that it's stated statutorily. And so this was kind of a solution to saying we don't necessarily always have a medical professional on staff, as was testified to thoroughly. There may be kind of during business hours, Monday to Friday, 9 to 5, that type of thing. But on the weekend, there's a lot less of there isn't the staffing to be able to do this at a correctional facility. And so the idea of doing this bill was to try and get everyone into compliance, since it was required that someone who was being held in protective custody and they were going to be held at the local jail or in the correctional facility. So this was bringing them into compliance since the liability would be on them. So we had a lot of discussion when we heard about the bill as it was introduced about problems throughout. So anyway, but what this amendment aims to do is just to really get at the heart of what the issue was, why this bill was brought in the first place, to get to resolve the issue that it was trying to resolve in the first place. And so what it does is it removes two things. They say the same thing in two different parts of the law. No person shall be lodged in a local jail or county correctional facility under paragraph 2 unless the person in charge of the facility immediately upon lodging said person in protective custody contacts a designated drug counselor, a clinical staff person of an approved drug treatment program with detoxification capabilities, or a professional medical staff person at a licensed general hospital emergency room to determine whether said person is indeed incapacitated. If and only if none of the foregoing is available, such medical or clinical determination shall be made by a registered nurse or registered emergency medical technician on the staff of the detention facility. So there is no, outside of essentially business hours, there is no registered nurse or registered emergency medical technician at the facility outside of essentially business hours, so on the weekend and things like that. So if somebody is brought in for protective custody, then it becomes, okay, who is the liability on? Is it on the officer who is bringing it to, bringing this person to the facility, or is it on the facility once they get there? And so it's created some kind of back and forth about who would essentially be liable for that. And what we've had is we've had people being turned away from correctional facilities because they do not have a person on staff to be able to do that. So it's a matter of whose judgment it is. So the sponsor brought this amendment. Representative Shapiro brought this amendment so that he could kind of cut away all of the other things and still try to address the essential problem that was happening in the first place. So taking out that section of law kind of alleviates the liability. Did I do a terrible job of explaining that? 'Cause I feel like I'm getting a lot of blank looks. I'm trying, guys.
If we could just have, you know what? I'd like 10 minutes. I want to read the actual statute so I can bump it up against the amendment. We're going to be recessed for 10 minutes. We are back on, and it's now continued discussion on the amendment. Last person who spoke, I believe, was Representative Newell. Anyone else wishing to speak on the amendment?
Very quickly. So basically, the amendment repeals the whole bill and just replaces it with these 3 lines. No?
A new section of law, if I'm not mistaken. Repeal the statute. It doesn't say repeal the amendment.
It says amend the bill by replacing everything after the enacting clause with the following. So it repeals everything else that was in the draft, except for this.
Yes, please. Okay. It doesn't look like we need help, does it?
Kate Horgan, New Hampshire Association of Counties. So this isn't amending the bill. This amendment amends the statute and only takes out the piece that says we have to immediately evaluate someone when they are in the correctional facility. Because if they are so intoxicated that they cannot form sentences, regardless of whether or not I have medical staff on board, I can't evaluate them or counsel them about, getting services. That is all this bill does. It takes out the concerns of the police chiefs and the sheriffs. So it just focuses on removing that section of law. So if you're looking at just the amendment, you can forget the bill and just look at current statute. Yes.
Yeah, we seem to have a, okay, so let's just all go through it together, class. Repeal the following are repealed. RSA 172.15, Roman 3, relative to contact requirements regarding incapacitated individuals. RSA 172B3, relative to contact requirements for incapacitated taken in an event. So amend the bill by replacing all after the enacting clause. What is the enacting clause? Where's the bill?
The enacting clause, Mr. Chairman, says being enacted by the Senate and House of Representatives and General Court are convened.
And
That's
that's
the
it.
enacting clause. So everything after that is replaced.
Oh,
It puts in 1, and then it says replace the words, the remaining words of this bill.
are all gone.
It says after the enacting clause, so it's the wording of the bill just
Well, no, I'm okay with it.
takes it all away, except for those 2 things.
Well, bust my buttons twice today. I'm going to change my mind. All right. So having said that, everything I just told everyone in the room that we don't talk about is gone. No, that's gone. That wipes all that out. Yeah, that actually took a bill that, in my opinion, was not so good and fixed some law that was already bad. So what's not to like about that? Oh, so everything we've just discussed, however, is immaterial until I get a second to the adoption of the amendment. You move to. Oh, okay. All right. Good. Yeah, got it. Okay, so I want to state it for all the members. The bill that we had is now, for the most part, except for be enacted by the House, gone. This new bill strikes out the 2 places in law where it said that they had to do a medical evaluation on somebody the moment they arrived for protective custody only. Obviously, we heard from law enforcement, if someone's got an obvious injury, they're getting them treated. They're calling an ambulance or what have you. They're not bringing them all broken to the jail. And if the jail sees they're all broken, they're calling an ambulance. I mean, in other words, no one's getting tucked away with obvious injuries. They only can be held for a maximum of 24 hours. So having someone evaluated to talk about, their abscess molar or whatever else irrelevant, most of them don't stay the 24 hours. Somebody comes and gets them. I think this saves our counties a lot of money. It doesn't put anybody in any risk. I'm not seeing the downsides. Any further discussion? Representative Murray.
Thank you, Mr. Chair. My only concern is if we're saying an evaluation doesn't need to be done, if someone is brought in, on drugs or something, and they're not evaluated, is there not a possibility of them going into an overdose while in a cell or like some other medical emergency that could happen because they were not evaluated upon entry?
It is my understanding that people that are in protective custody are monitored the entire time they're there. So it's not like normal incarcerated guests who are just, here's your cell, see you in the morning. The people that are in PC are monitored all night long because of the fact they're there because they are intoxicated. So if they were to, example, OD and fall out, I would imagine within moments somebody would be there with Narcan and they'd be calling a wagon to come get them. Representative Reed.
Thank you, Mr. Chairman. I don't understand. I mean, it just seems to me that law enforcement has a good handle on this, and they've been dealing with these situations for a long time. So why are we presenting a bill I don't feel is necessary?
I'd be happy to tell you.
Please.
Yeah. So if you look at the statute, the protective custody statute, the problem we've had is at some point in the past, somebody put in there to protect people, I would assume, from being put into protective custody who didn't need it, that they would be medically evaluated for the sole purpose, if you read the statute, to ensure they are indeed incapacitated. Times have advanced. Now, there's no way that the people in the jail and the cops are all going to be in cahoot and put a sober person in there. Nobody wants that risk. They've invented lawyers recently. So what it's done is remained in statute, and now they're starting to play hot potato with human beings. Well, we don't want to hold them. Well, we don't want to hold them. It's horrible. It's causing staffing issues. It's causing. So the original bill I did not like because it was huge, ponderous. This fixes the law, which is really what needed to be done, in my opinion. Further discussion.
And as I understand it, is that without removing these pieces, somebody has to evaluate them formally, right? Whether it's a drug counselor or whatever that may not be on staff. So that removes that piece because I would like to think law enforcement, correctional, and whoever can, after a little bit of experience, can determine whether somebody needs to be sent to the hospital or they're all set to stay here. So they don't need some person with alphabets after their name to get called in or whatever to say that.
Thank you. And again, I'd point out the existing statute that calls for this eval is not for their health. It's only to see if they're intoxicated. So I think that, to your point, law enforcement knows if someone's intoxicated, and so does the jail. Hold on. Representative Murphy, did you have something?
Thank you. Yes, I just want to say in my notes, I looked back and it seems that Section 3 of 172B3 was the biggest concern of the Superintendent of Chester County Department of Corrections, and that Captain Dustin Perrin agreed that taking that section out would not create any negative impacts. So there was agreement on that.
Yes, I agree. I believe the superintendent said if you're not going to do anything else, at least do that.
Yep.
And we're going to at least do that. Representative Selig.
Just to clarify.
Yep.
But this type of incapacitation is both drug related as well as alcohol related, correct?
Yes.
Thank you very
Yeah. Yes. Further discussion. Representative Mannion.
Thank you. This is the ghost corner over here. So, yeah, I agree. So if you get somebody that they're going to evaluate and they don't have somebody on staff, it's 2 a.m. because that's when most people are drinking heavily, or people I know anyways. And they're going to call somebody in. That could take 2, 3, 4 hours to get somebody to come in. That person could be sobered up by then. So it really, it's really a moot point. So I agree that removing these sections would be beneficial.
And in that time, while whoever it is coming from wherever they're coming to do this, someone could come and pick them up and they're on. And the whole exercise was a waste of time and money, and it just doesn't make any sense. Okay. So the motion is to adopt the amendment read by Representative Newell. I would ask the clerk to call the roll on the adoption of the amendment, which I like.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sytek? Yes. Representative Prue?
Yes, please.
Representative Janvrin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Lynn?
Yes.
Representative Tensar?
Yes.
Representative Harriet Gathright?
Yes.
Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Selig?
Yes.
Representative Wheeler?
Yay.
Chairman Roy?
Chair votes yes.
20-0.
20-0. The amendment is adopted. I would recognize Representative Newell to make a motion.
Make a motion for ought to pass with amendment?
Perry Gathright?
No, that
Oh.
was Murphy.
Representative Murphy. And any further discussion? Seeing none, I would ask the clerk to call the roll. Motions ought to pass as amended.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek, Representative Prue,
Yes.
Representative Janvran,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Lynn,
Yes.
Representative Tenzar,
Yes.
Representative Harry Gathright,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Selig,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
20-0.
20-0, the bill passes unanimously. No, any objection to consent? Seeing none, it'll go on consent. The executive session is closed. I hereby open the executive session on House Bill 1276, and I recognize Representative Mannion to make a motion.
Thank you, Mr. Chair. I make a motion of ought to pass.
Seconded by anyone?
Sure. I'll second that.
Thank you. Would you like to speak to your motion, Representative Mannion?
Yes, thank you, Mr. Chair. So this is a bill that we passed last year, repealing these prohibition against these weapons. It wouldn't do it for those that are under 18, just 18 and over. These are weapons that can be you could possess if you're a hunter, you can possess if you're law enforcement, but the general public cannot possess them. And a lot of these are antiquated weapons, and a lot of people have them for desktop type of knickknacks and stuff. So I think it's time we pass this, repeal that.
Thank you, Representative Prue. Would you like to speak to your second?
Yes. So, they talk about, oh, they're weapons and what have you, but they are less than lethal weapons. So if people can carry a firearm, now they have an option. If somebody attacks them, they can fend them off with these if they happen to be carrying them. But like the rep said, most people don't carry these anymore. They're just knickknacks and history things of days gone by. I'm older than dirt, so I kind of remember them. I figured I'd beat you to that.
I've heard that one before.
Thank you, Representative Janvran.
Thank you, Mr. Chairman. I'm reading directly from the Constitution of the State of New Hampshire, Article 2A, the bearing of arms. All persons have the right to keep and bear arms in defense of themselves, their families, their property, and the state. If these items are used in a defensive posture, we have that right. However, if they're used in an offensive way, it's already a crime. So I definitely support the OTP.
Thank you. Further discussion. Anyone else? Representative Wheeler on the melee weapons.
Well, I was going to call it the brass monkey. I don't know, but
As the rest of us all day.
You are now older than dirt.
there you go. Well, Representative Newman says that my brain is older than dirt, so I don't know. And I'm consistent with that. I support the OTP on this. I think it's silly to ban these devices, these weapons, when the police are able to use them, when hunters are able to use them. And for the layperson on the street, I mean, how do you know if someone's got a hunting license to be able to carry these weapons? So if you're being, I don't know, if you're trying to attack somebody and then they pull out brass knuckles, how do you know that that's not in violation of this section? They could have a hunting license. It could be legal. So I just think, we have some of us are so adverse to what could potentially come from these weapons that we're against the bill. But I think that obviously no one wants to see somebody get beaten up by a brass knuckle or a slingshot or whatever the third thing is. I don't know. But fact of the matter is people have a right to own these weapons. And, while it's not good, it's not great that people get attacked. People have a right to defend themselves on the streets. And I think of a woman who, might not want to carry a gun and, wants to carry some brass knuckles. That same woman could pick up a rock from the street and it'd be just as deadly as the brass knuckles. So if we're concerned about deadliness, we should ban rocks. But we all know how silly that is. So I support the OTP motion on this. And yeah, as Representative Mannion said, these are essentially knickknacks these days. So we're just legalizing a collector's item, and I think that's a worthwhile thing to do.
What you said actually reminded me of a commercial I saw not too long ago for a product for women. I think it was called the Claw, and it was something they could hold that had like a cat's claw, so they could, if an attacker came at. I mean, it's the same kind of concept. Somebody who's smaller and can get rid of somebody who's trying to accost them as they get in their car or what have you. Oh, you do, Representative Mannion, see? No,
You did have your hand up. I saw it.
he was doing the raise the roof thing.
Oh.
Representative Sitek. Representative Muse.
Yeah, I find it kind of incredible that a committee that is charged with criminal justice and public safety is poised to pass a bill that would actually make it easier for one human being to beat another human being to death. I think if you look at the kinds of injuries that these that these weapons cause, they're essentially a force multiplier. The injuries that they cause are things like fractured orbital bones, broken teeth. They require plastic surgery. In some cases, people don't recover when they're beaten by people who are using these weapons, which is one of the reasons why we currently ban them under state law. We don't necessarily want people with these weapons in bars and public gathering places. We don't want them in schools. And the fact that we're prohibiting selling and distributing them under this particular bill to people age 18 and under doesn't necessarily keep them out of our schools because we actually let people go to
18 and over, Representative.
we actually allow people who are 18 and over to attend our high schools. So I have been against this one in its form last year. I continue to be against it. I don't think it's good public policy from a public safety standpoint, and I will oppose it.
Thank you. I would hazard to say that I've seen the results of the damage of some of these weapons, and I've also seen the results of on a woman of being forcibly raped. And I would I'd advocate the person who did it get the brass knuckles before she gets raped. Further discussion. Seeing none. Representative Peru.
So that was kind of going to be my point, is that someone is okay leaving a woman defenseless or anybody defenseless to be attacked by someone else is unacceptable to me, right? I'm not just going to say, yeah, okay, it's okay if somebody attacks you. If somebody chooses to attack me, I'm going to defend myself. And if they get injured, well, that's too bad, because they made the decision to attack me first. Not that I attacked them first, but I'm going to defend myself with whatever I can. And if I have a choice of less than lethal, not a gun, so much the better. That person will probably survive. But if my only option is a firearm, they probably will not survive. So you're taking away my chance to do less than lethal force. I don't think that's right at all.
I have a question, and Representative Muse actually made me think of it. Would this allow, let's say, a senior in high school to bring these into school? I'd like to know that.
Mr. Chairman.
So I'm sure the school can make a policy.
Correct.
There are no weapons in school.
Well,
that's
that's
already-
not necessarily true, because schools, we can carry guns to vote at a school. But would it be different though, because they're actually school children?
They're a student, and
So they have to follow
under
the school policy. Yeah.
You're voting. It is not a school. It is a voting.
Okay. I just want to be
Well,
clear.
and
I'm
Mr.
not gonna-
Chairman,
I would not be in favor of students carrying these around the halls of the school. Representative Mannion first, and Representative Eric Gafford.
Thank you. A couple of things. So this being referred to as an offensive weapon is wrong, because it's a defensive weapon. anything can be an offensive weapon. But this goes back to the old saying that if just because it's illegal doesn't mean the person who wants to go out and use it as an offensive weapon is going to care. They're not going to say, oh, I can't carry a brass knuckle, so I'll have to grab a stick on the way over there. They're going to use it. So all this is doing is preventing those people, women who don't want to carry a gun. They're afraid of carrying a gun, but they have some sort of defense. And if the person who attacks my daughter has an orbital fracture, so be it.
Eric Gathering.
I actually agree with everything that Representative Muse said, and I do have a true concern for the school. Because keep in mind, here in this state, 24 years old, you can still be in high school.
Yeah, I agree. But the point
And I
was made, and it's correctly, that if the school has a policy, then the students have to follow it. They wouldn't be able to get out of it with this.
It's not considered a weapon when you take it out. It's a weapon now. She mentioned something.
It's a weapon.
It is a weapon.
but it's
A
illegal.
gun's considered a weapon.
I'm not talking about a gun. We're talking
I understand that, but that's legal to carry,
Yeah.
and that's a weapon. So just
And they
because
can't
it's
carry it
legal
to school.
doesn't mean it's a weapon.
Right.
It's not
yeah.
a weapon. It's still a
Yeah,
weapon.
the school can say that they don't have, they can just specifically say no brass knuckles, no nothing. You can't. I think they already do, most of them. Representative Wheeler.
Thank you, Mr. Chairman. And I also just have to say, this doesn't increase the prevalence of brass knuckles. They're not going to be a million more brass knuckles because we passed this bill. Have all of us see? Oh, maybe we will. Maybe we'll start opening up brass knuckle shops and stuff like that.
Exactly.
I don't know if that'll actually happen. I think that's a little ridiculous. People will sell these brass knuckles, and they should be allowed to sell them because people have a right to defend themselves with these knuckles. If someone gets attacked by someone with brass knuckles, Representative Muse, that person will go to jail for an assault charge.
I do not need you to lecture me. Thank you very
Well,
much.
then don't do it to us,
All right,
Representative
that's
Muse.
enough.
Okay?
Address the chair.
Thank you, Mr. Chair, and I apologize for that. If someone gets attacked, they will go to jail for an assault. If they're in school, if they're on the street, if someone goes out and starts beating people with brass knuckles, the police will throw that person into prison where they belong. But if a woman who has no way to defend herself gets attacked by a 6'4" person on the street and has the brass knuckles to be able to defend themselves, and then as Representative Mannion said, that person gets laid out, so be it. They shouldn't have attacked a woman on the street, and they shouldn't have been attacking people, and that woman has a right to defend themselves with brass knuckles. Or, as I said, they could pick up a rock from the forest if we don't make this bill legal.
Very good. All right. Representative Newman. Let me guess. You don't like it.
I'm not sure that this bill does what it intends, and I'm just talking about the wording of the bill. It says to repeal RSA 159-16 is repealed and reenacted as follows. 159-16 says whoever except as provided by law. In this amendment, as I read it, says any person under the age of 18 who carries a person or a slingshot or mentality shall be guilty of a violation, and such weapon so carried shall be forfeited to the state. Does that, since you've repealed it, does what you've repealed, it says whoever, does this now only apply to people under 18? I'm confused about that.
I think so. The language before made those items illegal. The language now would say anyone under 18 who carries these items, it is illegal.
Okay.
So I think that's what that does.
I'll look at the other sections. Thank you very much.
You're welcome. With that, I'm going to ask the clerk to call the roll. I think we've, no pun intended, beat this one to death. Representative, the motion is ought to pass. Huh? What? Which? Yeah. Well, I don't want to do that, but did she tell you where she's going? Oh, Representative Schiller. I don't want to do that to her, so I'm gonna, if she's right outside. Okay. All right. Call the roll. Ought to pass.
Vice Chair Rhodes.
Yes.
Can we restate? She wasn't here. But the question.
Yes, she was.
Oh, okay.
Vice Chair Rhodes. Representative Pratt.
Yes.
Representative Sytek, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Lynn,
Yes.
Representative Tenzar,
Yes.
Representative Harry Gathright,
No.
Representative Muse,
No.
Representative Bolden,
No.
Representative Bradley,
No.
Representative Murphy,
No.
Representative Newman.
No.
The clerk votes yes. Representative Newell,
Yes.
Representative Selig,
No.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
13-7.
13-7. Again, it is not going on consent. Obviously, reports please by Tuesday. And with that, I close the executive session on whatever House bill that was. What is this? 1276. And with that, what's next? 1319. Who's good? Representative Muse, will you be doing the minority report? Okay. 1319, I open the executive session and I recognize Representative Muse for a motion.
Mr. Chair, I move to move amendment 2024-0209 and move HB 1319 ought to pass.
Is there a second on the motion? Seconded by Representative Wheeler. Would you like to speak to your motion, Representative Muse?
What this amendment would basically do is correct a one-word typo in the original bill that was pointed out by Representative Janvrin during the public hearing. So that's basically the story on the amendment, and I'll talk about the bill when we get to the bill.
Do you want to speak to your second, Representative Wheeler? Okay, that was pretty clear cut. I'll ask the clerk to call the roll on the amendment.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sytek, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Lynn,
Yes.
Representative Tenzar,
Yes.
Representative Harry Gathright, Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Selig,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
20-0.
20-0, the amendment's adopted. I recognize Representative Muse for a motion.
Mr. Chair, I move HB 1319 ought to pass with amendment.
Seconded by Representative Wheeler. Representative Muse, would you like to speak to your motion?
What this bill does is it essentially amends New Hampshire's revenge porn statute to include digitally generated synthetic images. So one of the things we've all been reading about is how essentially AI is changing a lot of things. The ability to do things like create deep fake images is something that is harming not only celebrities, but it's harming people's daughters. It's harming 24-year-olds who try to get a job and find out that there's a deep fake image of them on Pornhub that their potential new employer is actually finding when they do a Google search of them. The bottom line is that we make the non-consensual dissemination of these types of images when they're photographs a Class B felony in New Hampshire, and the act of taking the face of an innocent person and pasting them over the body of another person doing something that the person who owns the face wasn't a party of and didn't do, I think is it's reprehensible. And we have a lot of work, I think, to do as a legislature to try to figure out things like AI and try to figure out, what are some of the ways that we can, in a common sense kind of way, begin to protect people more in New Hampshire than they currently are, and I think that there will be some work that's happening at the national level. At least I hope there's some work that actually emerges from Congress, because I know people in both parties are concerned about this. But I think this is one small thing that we could do here in New Hampshire that would actually address a situation that we're already starting to see. And we actually heard testimony from the state police that this is something that, yes, we already are starting to see this in our state.
Thank you. Would you like to speak to your second, Representative Wheeler?
Yes, please, Mr. Chairman. Really quickly, just as a young person who is on the internet a decent amount and sees this, it's concerning. I mean, the rise and prevalence of AI and revenge porn and fake synthetic images that are being created to, I mean, do horrible things to people. I mean, and if you're a celebrity, then you have the wealth, the status, the power to be able to, solve that issue in whatever way would be, you could solve it, prosecutorial or whatever. But if you're a regular person on the ground, you have no recourse to be able to get somebody addressed with this, and that person can just keep making these images, and well, you can't do anything about it. Well, now we can, Class B felony, and I think that's a really good thing, and I appreciate Representative Buse for bringing this bill forward.
I agree. Thank you. Representative Muse and I have both been a victim of that recently together. I don't think it's been on Pornhub yet, but it has made the rounds. Yeah. Further discussion. Representative Lynn.
Yeah, I just raise an issue. We have in judiciary, and in fact, we're going to probably exec it on March 6th, of what I think is a very similar bill dealing with dealing with deep fakes. And basically, our bill would creates a felony to have it, to use a deep fake. It creates a cause of action for that, and it also has a provision prohibiting its use in political, unless there's a disclosure of some kind. So I'm just, I haven't looked at your bill, so I don't know whether your bill may be better than our bill. I'm just saying, I just wanted to let the committee know that there is another, and maybe, I suppose it's possible some other committee might have, commerce or something. I don't know, but just to let you know.
We do have five. I know there are 5 different bills that are dealing with this in one way or another. We actually have another bill I think we're going to be execing later today that also kind of gets into this territory. As I looked at it, and the reason why I decided to focus narrowly on this is I think that to me this seems to be a pretty open and shut extension of our current law. It seems to be something we can get our teeth around now. With some of the other things, there are First Amendment issues that are involved. There are a lot of complexities with trying to regulate this in the right way. So this just struck me as something that we could do and get started with.
Yeah, I'd rather pass them and let's sort it out at the floor, which one's best, rather than have everyone assume that someone else is doing it. But we will be actually probably deferring to you in a couple minutes on one of the bills that we are going to address. So, well, now we're going to have further discussion, Representative Prue, because I think you want to stay longer. So the motion before us now is to adopt the amendment, or did we do that? We did that. Motion's ought to pass. I'd ask the clerk to call the roll.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sytek? Representative Prue?
Oh, yes.
Representative Janvrin?
For Taylor, yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Lynn?
Yes.
Representative Tensar?
Yes.
Representative Harry Gathright?
Yes.
Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Salick? Yes. Representative Wheeler?
Yay.
Chairman Roy?
Chair votes yes.
20-0.
20-0, the motion passes. Any objection to consent? Seeing none, close the executive session on House Bill 1319. Open the executive session on House Bill 1336. Recognize Representative Janvrin to make a motion.
Mr. Chairman, I move OTP.
Is there seconded by Representative? Who seconded? Oh, Rhodes did. Would you like to speak to your motion?
Yes, thank you. Little story. I used to work for a federal agency that requires you not to have a firearm on the premises, and locked my firearm in the car and parked off premises so I could be able to go hunting after work. I work third shift for this agency. I think that if we've extended the castle doctrine to our homes and our cars, that our cars are pretty sanctisanct. So the sanctity of that car, you should be able to keep a firearm there as long as it's locked and secure from outside pilferage. I believe that it definitely is something that should be allowed in the state.
Representative Rhodes, like to speak to a second.
Sure. Thank you, Mr. Chairman. Basically what Representative Janvrin said is what I would say. I would just add that there is some debate and some question about, well, what if somebody breaks into your car? Well, now you're a thief, and that's illegal to break into my car. And, if I'm respecting the wish of said business and not taking a firearm in, which they wouldn't know, but if I did respect that and I left it in my car, I feel like I've at least made a happy compromise. Was able to keep myself protected wherever it was I was going, and then respected the wishes of said business and didn't take my firearm in. And with that, if you don't want to find a gun in my car, don't break into it.
Thank you. This is what I would say. We have extended to businesses and frankly people the right to say, I respect your Second Amendment rights, but not in here. Restaurants are free to say you can't come in. Bars are free to say you can't come in. And if you do that, you can be prosecuted for trespassing, I believe. So if businesses, your employer says, you know what, your rights are your rights, but not in our business, we respect that. But at the same time, we do not want to disarm people of their Second Amendment rights for the remainder of their trip, the remainder of their day. Many people work late and they have a long commute home. Their car breaks down on the side of the road. They're near no firearm. Every day in the news, we see stories of someone found somewhere who disappeared. I don't think we want that in New Hampshire. Firearms, we have a specific crime of larceny of a firearm, I believe, which is a felony. So if someone breaks, it's not the same as breaking into your car and stealing your Kenwood and your bazooka base tube. It's stealing a felony is stealing a firearm. So I believe we've covered that in the law. So I think that's all I have to say in that. Further discussion, Representative Murray.
Thank you, Mr. Chair. Representative Janvrin, I just wanted to ask, you said that Castle Doctrine does include your car?
It does.
Okay, thank you. Because I feel like my biggest concern with this is just we're getting into a gray area of property rights and personal rights. And I don't know, that makes it challenging for me to support OTP.
Representative Muse.
What the Castle Doctrine doesn't include is your car when you drive it onto somebody else's property. I think that's something that we need to focus on a little bit here. I know my employer for almost 30 years had me sign a non-compete agreement. I had to sign multiple non-disclosure agreements over the years. There are a whole bunch of things that over the years I was asked to do that interfered with my rights. And I did, and I agreed to those things because they were a condition of employment. We just had a bill, where we talked about, a school being able to set a policy, to exclude brass knuckles if we had a problem with brass knuckles in schools. Here we have a situation where an employer, for instance, a daycare center, and I raised this during the public hearing. A child care center, you could have somebody who, yes, has a weapon in the car, and 19 out of 20 times they remember to lock the door. But this one day their phone went off, they got a message, and for one reason or another, they didn't lock the car. If that car happens to be parked near the kids' playground, there's a chance that kids might try the door and get in the car. And, the bottom line is this is yet another bill that's in search for a problem that I don't think exists. I think the vast majority of gun owners who run into a situation where, for instance, they want to go shooting after work, they're just going to put the gun in the trunk of their car anyway. They're going to stuff it under the seat or put it in the glove compartment. I don't think there's a law that we can pass that's going to change that one way or the other. But I am very concerned with the kind of message that this sends, and I'm also concerned with the fact that, you know, here we are once again flip-flopping on the issue of the rights of property owners, and you know, it just seems we kind of go back and forth depending on which way it seems to suit us. So that's essentially the problem that I have with the bill.
Thank you. Representative Mannion.
Thank you, Mr. Chair. The difference I see here is when you sign non-disclosure agreements or any other kind of agreements with your employer while you're in the building, I'm going to guess that none of those infringe on your constitutional rights other than this. And they're infringing on your constitutional rights when you're off property, traveling to and from. So I think that might be the difference in this.
Awesome. Representative Muse, did you want to address that to the chair?
Yeah, there is an issue of, you know, of free speech as well. There also, you know, is an ongoing issue with things like, you know, in New Hampshire and other states with non-compete agreements, which can restrict your ability to move and to, you know, to earn an income. So there are, you know, and these are essentially things that we've kind of agreed to in the law to allow employers to do their business. And one of the things that they can, and I worked in HR for an awful long time, and one of the things that they can do is basically hand you a code of conduct or essentially a rule book, and essentially have you sign a document that basically says you will act in accordance with these policies. And if you do not act in accordance with these policies, you can be terminated for cause.
Representative Prue.
Well, the difference between a non-disclosure in the First Amendment and this is my life is not in jeopardy when I can't say something. But if I can't bring my protection with me to and from work, and I stop at the store and somebody tries to rob me and I have no defense because I couldn't bring it to work, that's the difference, right? And if it stays locked in my car, it's not affecting me at work.
Representative Mannion.
Thank you, Mr. Chair. As far as the First Amendment is concerned, that's infringement from the government, not your employer. So it's a little bit different. When I'm off property, my Second Amendment right to carry has now been taken away by the business. But if they ask you not to speak about something, that's not the government telling you to do that. So that doesn't apply. The First Amendment doesn't apply to that.
What you mean is the First Amendment restricts the government from banning your speech, not your employer. Your employer is free to ban whatever it wants, and you're free to seek other employment should you so desire. Representative Wheeler, then Representative Bolden.
Thank you, Mr. Speaker, Mr. Chairman. I was told mistruths about this in caucus. I'll be voting the way I said I was going to vote in caucus, but we'll probably change my vote on the floor. That's all I have.
I have no idea what you mean, but okay. Representative Bolden.
Have we covered how this affects when the federal government is an employer? Because you can't have guns on like postal service property. They have a.
Yeah, that's changed, I think, right? But no.
Since when?
Yeah.
Case law?
You
Overruled
thought you were
Postal
on
Service?
top of it, but you're not. No, I don't know.
Well, I'll be Googling this and raising my hand again as needed.
No. To answer that question real quick,
Is that
this would
all
have zero
federal property?
effect on postal property or federal if your federal government's your employer, the federal rules, we cannot tell the federal government they can't fire you because you violated that. We would, the preemption would stop that, I believe.
But doesn't it become pretty muddy at that point where maybe someone hears about this if it passes into law and isn't vetoed, and then they don't understand the minutiae? I mean, that's really complex.
Ignorance to the law is not a defense.
I know, but that's what I'm saying is, are we setting people up for a problem here?
I personally will put it on my Facebook page. Representative Selig.
Thank you. Not surprisingly, I don't really support this law, but the bigger issue that I see is the enforceability or lack of enforceability. Who's monitoring, who's checking, and so I just don't support it because I don't see it as
Explain what you mean, please.
so
monitoring
who's,
what?
who's monitoring, who's checking to make sure cars are locked in the parking lot? Is the employer doing that to make sure that if you are someone they know is likely to be carrying a gun, they're going out to check that your car is locked or not? Like, it gets to me. There's too many complications for me to feel comfortable with it.
Okay. I believe, though, it exempts the employer from liability, so they wouldn't feel the need unless they were paranoid to check your car. I think we've pretty much dealt with this one. The motion on the floor is ought to pass, and I would ask the clerk to call the roll.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Lynn,
Yes.
Representative Tenzar,
Yes.
Representative Harry Gathright,
No.
Representative Muse,
No.
Representative Bolden,
No.
Representative Bradley,
No.
Representative Murphy,
No.
Representative Newman.
No.
The clerk votes no. Representative Newell,
No.
Representative Selig,
No.
Representative Wheeler,
No. Nay.
Chairman Roy.
Chair votes yes, yay.
10-10.
10-10, the motion fails. You can go through another vote if you want to, or we can just leave it and let it go to the floor with no recommendation. I don't think we have to do it. Yeah, I don't think so. Yeah. Yeah, okay, so, yeah, we have no motion, so it goes with no recommendation. Again, on this one, reports, I would, Representative Muse or someone else going to take this one? For the minority report. Representative Muse is going to do it. Again, please, everyone, no joke, Tuesday, I need those reports. Let me see, what do we got?
Excuse me, Mr. Chair. Will we have a list of who's doing the reports?
Yeah, I think Representative Rhodes has got that and she'll
Okay.
send it out.
Thank you.
And the clerk as well. Everyone but me. So now we've got, what are we up to? What are we up to now?
I got it.
1344. Okay, thank you. Hereby open the executive session on House Bill 1344 and recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I make a motion to ITL House Bill 1344.
Is there a second? Seconded by Representative Murray. Representative Rhodes, would you like to speak to your motion?
Sure. Thank you, Mr. Chairman. If anybody could help me out with this, I would gladly take it. I do not, if I'm not mistaken, I don't think that this sponsor showed up to introduce the bill, and I don't know that any of us really remember exactly what it was about. But my understanding is that it is very much illegal to try to solicit minors for sexual activity. So other than that, I really don't know too much about what this bill did. So like I said, I'm happy to take any help I can get it.
Representative Murray, would you like to speak to your second?
Thank you, Mr. Chair. Yeah, I would reiterate what Vice Chair Rhodes said. The sponsor was unable to come in and introduce the bill. None of the co-sponsors attended. And the only testimony came from an officer who was in the room when we questioned them about possible implications of passing this. It seems like everything that is trying to outlaw is already outlawed, and it's not clear why this is needed.
I would say this. I think it is a great disrespect to the members of this committee in our time to submit a bill, not show up to introduce the bill, and that's okay. Things happen. I haven't got an email from anyone. I don't know if anyone else did. Representative Wheeler's indicating he may have.
We did it was within a bunch of emails, but Representative Perez, the Republican, Representative Perez did send an email to the committee apologizing initially, and then sent an email a couple of days ago apologizing that she wouldn't be able to be here for that. I can forward that to you.
That's okay.
Oh, yeah, well, all right. So I'm going to send an email back saying I apologize. I'm not able to pass your bill. I just don't understand it. If it was important, I would think that there were co-sponsors on the bill. Anyway, I'm wasting more time. Anyone else want to discuss? Representative Manion.
Thank you, Mr. Chair. Yeah, I agree that this is already in law, so there's no real reason to pass it. And I want to thank Representative Murray for always having the history on this stuff because I can't remember any of it.
Ditto. Okay, with that, I'll ask the clerk to call the roll. The motion on the floor is inexpedient to legislate.
Representative Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Manion,
Yes.
Representative Reed,
Yes.
Representative Lynn,
Yes.
Representative Tenzar,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Selig,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
20-0.
20-0, inexpedient to legislate passes. Any objection to consent? Seeing none, it goes on consent. Hereby close the executive session. That I open the executive session on House Bill 1500, and I will make. No, Representative Rhodes is going to make a motion, please.
Thank you, Mr. Chairman. I move interim study for House Bill 1500.
Seconded by Representative Wheeler. Would you like to speak to your motion, Representative Rhodes?
Sure. Thank you, Mr. Chairman. So we've heard some conversation about AI, and without talking about other legislation, I have to for a second and let it be known that Representative Lynn, who will probably wish he did not come today, actually did mention what he mentioned earlier, that there was a pretty in-depth bill over in the Judiciary Committee. And it was basically discussed that instead of us trying to piece together different pieces of legislation to make something happen, it might be a better idea to interim study this. He can look at the legislation that we have, the legislation that he has, and hopefully come up with some good legislation around the concerns that a lot of people are seeming to have.
Thank you, Representative Wheeler. Would you like to speak to your second?
Yes, please, Mr. Chairman. Thank you. I co-sponsored this legislation alongside Representative Linda Massimilla, for the same reasons I articulated in 1319, very concerned with just the prevalence of AI in general. And this is more broadly the unlawful distribution of misleading synthetic media. They're going to create whole new realities with what they can do now. It's not just Photoshop where you can tell kind of, the wave looks a little off, so it's clearly Photoshop. No, this is hyper realistic AI generated imagery and videos that can, for the layperson, not even unintelligent people, but the layperson will see that and be bought into the narrative and then come up with a whole opinion on something that is just completely false. And I think we saw that, the worries of that with what happened in the primary election with a robocall of, a fake AI President Biden. Come on, Jack. He had thrown out a call and people were convinced by that. That's really concerning, when we're talking about these robocalls and all this other stuff. So I would support interim study. I ultimately would hope, and I know that you had asked the speaker for this, that there would be some sort of commission or something like that that the state government could look at so that we could come with just the general topic of AI and how the state government could approach that in a way that would be meaningful and actually address something for the constituents here in this state who would be misled by the prevalence of this new technology creating a new paradigm in our world.
Thank you. That's actually one of my summer projects to look at. I think that for too long we are playing catch up with technology by legislating after things are already out, and I think we're concerned about images and phone calls. I'm concerned about we've almost had war start already over pictures that were not real. So I think that we really got to get a hold of this. Having said that, Representative Lynn does have a comprehensive bill. We passed one bill earlier. Now they have that one, plus I believe there's a few others. I think we have enough AI subject matter there to work with. So I agree with interim study. Representative Reed.
Thank you, Mr. Chairman. I agree with the interim study, and that something definitely needs to be done. My only concern with this bill was that who's going to be, there was a heavy focus on political, points. And my concern with this is who's going to be the designated arbiter of truth, and will this be used as a form of censorship? I think we need to put guardrails in place to ensure that the truth is the truth, and not one group has say over what is their definition of truth. That is my concern. Thank you.
Yeah, I agree. That's in any type of thing like that, you have to, at the end of the day, wonder who's checking the truth checker. Representative Mannion.
Thank you, Mr. Chair. While I think I could benefit from a little bit of AI myself, I agree with both Representative Wheeler and Representative Reed.
Representative Janvrin.
Thank you. Thank you, Mr. Chairman. In looking at my notes for this bill, I noticed I wrote down a few notes. One is that there was no intent as an element of the crime. There was no mention of social media companies being liable for distribution. It seemed to be slanted to regulate speech for elections mostly. And I will note that the Federal Communications Commission and the Federal Election Commission have already taken up this subject. I think it might be useful under interim study for whoever works on that to look at what the Federal Election Commission and FCC have come up with for their regulations so that we can probably codify them in our statute.
Thank you. See no further, I would ask clerk to call the roll. The motion on the floor is interim study.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sytek, Representative Prue,
Yeah.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Lynn,
Yes.
Representative Tenzar,
Yes.
Representative Harry Gathright, Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Selig,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
20-0.
20-0, the motion of interim study carries. And with that, I'll close the executive session. This will go on consent unless you have an objection. I thought no objection, it'll be on consent. And with that, I open the executive session on, what's next? 1711, House Bill 1711.
We can get to it. We can get to it.
Yeah, I see it. Oh, okay. So 1711, I am opening, if you stand by just for a moment, I need my calendar. 23rd, first we're off.
Just so everybody knows, we started opening at 9:30, and the chairman doesn't have to call them the exact order that they're on here. He can just open them as he wishes or not open them.
Okay, so I did open House Bill 1711. I'm going to recess House Bill 11 executive session to March 6th. That's the week after our vacation, I believe.
1711.
Is that correct? Make sure I got that right.
17.
March 6th at 9:30 a.m. And that's good on that date? Okay. And with that, I'm going to open the executive session on House Bill 1539. And I'm going to recess House Bill 1539 until March 6th at sometime after 9:30. And next, I'm going to, let's see where we're at, 1528. Yes. I open executive session on House Bill 1528. And we have an amendment. I would recognize Representative Murray to make a motion.
Thank you, Mr. Chair. I move adoption of Amendment 2024-0855H. It's House Bill 1012, and the amendment is 0855H.
It's the 1528.
The bill is 1528.
Okay.
The amendment that she's trying to offer,
Is?
085.
No, she's on the wrong bill.
It's 0737H.
Thank you. Yeah,
Well, everybody like got all
we was trying to
nasty.
get
She made a mistake. What is it? 0737?
I need a second. Okay, thank you.
That's fine. Take a second. While you're taking a second, I need to correct the record. I recessed House Bill 1539 to March 6th, and I actually meant to say March 8th at 9:30. So it is, and there's, you can talk to Representative Wheeler about that, but it should be the only thing that day, so it'll be 9:30 a.m. No, one's on the 6th.
1539 is the 8th.
Yeah, 1539 is the 8th, and 1711 is the 6th. And that's, I'll keep Friday open. That'll be just the only thing so we can get in and get out of here. However, you'll see that the 6th will fill up. So just mark your calendars, the 6th and the 8th. The 8th will only have that morning quickly, that bill. And then the 6th, we will have a full day of work because we have a couple bills that have been referred to us from second committees. Because the person who
Well, Mr. Chairman, I mean, if everyone's going to be upset about it, here's what I can do. I can
He's gonna be in Florida,
I can call my grandmother, and here's what I can do. I'm
You're not gonna lay the grandmother.
I'll take I will call my grandmother, and I will be back on Tuesday the 5th. I will do
No,
that.
that's fine.
I absolutely will.
My brother's wife is going to be induced on the 4th, so I'll
4th?
be having a sub of March.
Oh, okay.
So
yeah.
on this topic,
You're going to be gone for the whole week?
I don't know. I haven't actually booked my flight yet.
All right. Anyway, the 8th, it stays, 6th and 8th. And with that, Representative Murray, you are back to introducing your...
Thank you, Mr. Chair.
Chill out. Okay, go.
Thank you, Mr. Chair. So Amendment 0737H to House Bill 1528, I made after we discussed this bill the first time. It changes the language to line up with what is currently the data that is currently collected by the state police when they are on Northern Border Patrol duty. I forwarded an internal policy document from the state police to all of you so you can double check for yourselves if you'd like. And then it makes, basically it just matches their internal documents and then their forms that they use when documenting an encounter at the border. It doesn't add anything additional. It just ensures that the information that they collect is sent to the Speaker, the Senate President, and the Governor.
Thank you. Who seconded that? Representative Salig, would you like to speak to your second?
Yes, thank you. I just want to say, I think the importance of having data that we can all easily access so that we can make the best decisions for all our constituents is really important. And this is just a bill asking for data to be provided in a way that we can easily access it.
Thank you. I tend to support the bill because it isn't asking for new information. It isn't asking for the police to make opinions. It isn't asking them to do anything other than they're already doing, and to get the data over to the people that we'd like to have eyes on it. So I think it's fine. Further discussion. Representative Zitek.
I'm not happy with the state police policy because it says race. Who determines race? Is it self-identified? Is it determined by the trooper? Maybe there's an answer to that, and I'll listen to it. But I don't like race, period. I'd like country of origin, because I don't know, race? I'm just not, I want country of origin.
This is information that they correct when they make an arrest, just to be clear. That, yeah, so Representative Murray, did you have your hand raised?
I was just going to say that I was originally considering adding in country of origin, but because that doesn't match up with what they're currently doing, I wanted to make sure that we weren't asking them to change all these forms and their current methods for tracking the data of encounters. For race, I'm trying to find, maybe just give me a second, but I do have a copy of the forms they use, and I can check and see if that's something that they assume or ask people to self-identify.
Okay, yeah, I don't know how they do that when this is an arrest form you're talking about, correct? Yeah. Yeah, Representative Mann, you can speak
Thank you,
to
Mr.
that.
Chair. So unless I'm wrong here, but if it's an arrest or something when somebody's in custody and they self-identify, I would never guess. It would be unknown if I don't know. So it would just come up as unknown, and that data would be just what it is.
Yep. Okay. Further discussion. All right. With that, the motion is to pass, or excuse me, to adopt the amendment. And I would ask the clerk to call the roll.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek,
Yes.
Representative Prue,
Yes.
Representative Janvrin,
On the amendment, no.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Lynn,
Yes.
Representative Tenzar,
Yes.
Representative Harry Gathright, Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Selig,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
19-1.
19-1, the amendment is adopted. I recognize Representative Murray to make a motion.
Thank you, Mr. Chair. I'd like to motion for ought to pass with amendment.
Seconded by Representative Harry Gathright. Would you like to speak to your motion?
Thank you, Mr. Chair. I think, it's clear from our discussion what this bill does. It just asks the police to transfer the data they're already collecting to the legislature. Pretty simple bill, and I appreciate your support.
Representative Harry Gathright, would you like to speak to your second? Anyone else? Discussion. Seeing none, ask clerk. Oh, what? Oh,
I'd
Representative
just like
Sitek.
to point out the difficulty with race because I heard from somebody just the other day that was raised white, as a matter of fact, and doesn't think so.
Thank you. I believe, though, that this form and the information they've been collecting, they've been doing it pretty much 50, 60, 70, 80 years. I don't know how long they've been doing it. However long they've been arresting people. I would have a problem if it was asking them to do something new and make a determination as to someone's race. Further discussion. Seeing none, I ask clerk to call the roll. The motion on the floor is ought to pass with amendment.
Vice Chair Rhodes? Yes. Representative Pratt?
Yes.
Representative Sitek?
Yes.
Representative Prue?
Yes.
Representative Janvrin?
No.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Lynn?
Yes.
Representative Tenzar?
Yes.
Representative Harry Gathright? Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Selig?
Yes.
Representative Wheeler?
Yay.
Chairman Roy?
Chair votes yes.
19-1.
19-1, is there an objection to consent? Representative Janvrin?
Yes.
Representative Janvrin objects to consent. It will go on the regular calendar. With that, I close the executive session. And stand by for a second on an amendment for the next.
Mr. Chair, while we're standing by for that, can I just quickly take a minute and go over these things with Representative Murray? Because I think a lot of people have questions as well, just while you're doing that real fast.
Yeah, we're on break until 3:30, and then we'll take up the last bill and be out of here a couple minutes after that.
So if anybody was in here wondering who did what or who owns what reports, the clerk and myself are just going to compare. Good God. We're going to compare our notes. So if you have any questions, now's time to find.
I'm opening executive session on House Bill 1366, and I'm recognizing myself for a motion to introduce an amendment. Can I have a second, please? Second by Representative Prue. I'm introducing amendment number 011H. This amendment, what it does is it takes, if you recall during the testimony, there was an issue of people getting their suspension and then serving it out when it wasn't voting season anyway. So what all this does is it changes the time period. The key sentence is the last one. It says the period for the loss of the person's privilege to operate a boat shall be between Memorial Day and Labor Day. So that means if you get your right to operate a boat suspended because you were operating reckless and dangerously, it's actually going to hurt you because you can't operate the boat when you would be normally operating a boat, versus being able to sit around all winter and say, haha, I got suspended, but it doesn't matter. Questions? Seconded by, who seconded that? Representative Prue, do you want to speak to your second?
It packs the punch when they would be most hurt by it during the summer. So, yep.
Thank you. Any further discussion? Representative Wheeler?
I just have a question, Mr. Chairman. And this might be because for some reason, I'm missing the notes from 118. But what was it before the Memorial Day to Labor Day?
It was from the point of when the court suspended the license for whatever.
So you could have it in the winter.
Yeah, exactly. If you went to court
on Labor Day.
Yeah, if you went to court in October for something you did in July, your license is now suspended for 60 days. Yeah, no. So yeah.
I wrote May to September, whereas you actually put the holidays.
Yeah, the holidays, because those are generally the days people boat. You take your boat out mostly on Memorial Day, and most people put their boats up Labor Day.
I don't.
Yeah,
I don't have one, so.
Yeah, I actually I used to have a bass boat, and what they say is the happiest and worst day of your life. You get, they're very expensive to maintain, and in any event, any further discussion on the bill? Representative Selig.
Thank you. I really support this, and I support the modifying the timeline to being during the primary summer months. As someone who has nearly been run off the water on Winnipesaukee on more than one occasion, and wishing that those people didn't still be able to drive till they learned how to do it properly, I very much appreciate it.
Thank you. Representative Newman.
I'm just curious about the last sentence. It says, any unserved suspension will be continued to the following boating season.
Yeah.
Does that take
Yeah.
it back to the between Labor Day?
Yes, that would. So in other words, if you got your boat, your license suspended in July, and you didn't get the full 60 days in, whatever was left would carry over to the next after Memorial Day.
Right, but I just didn't know if it took it back to between Labor Day and May. I mean, it's different wording than the original.
Yeah,
penalty.
I think that
I'm
because
not sure. Just wondering. Thank
no,
you.
no, it's a good question. I think that since we delineated it by saying Memorial Day and Labor Day, it's clear that that's the boating season. The court will look at and say. Representative Lynn, would you agree to that?
I do. I agree.
Okay, thank you. Representative Sitek.
Are we talking about the bill or the amendment?
Well, we're talking about the amendment because it
Or-
replaces that part of the bill. Seeing no further questions, I ask the clerk to call the roll on the amendment, and the motion is to adopt the amendment.
Vice Chair Rhodes? Representative Pratt?
Yes.
Representative Sitek? Representative Prue?
Yes.
Representative Janvrin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Lynn?
Yes.
Representative Tenzar?
Yes.
Representative Harriet Gathright? Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Salick?
Aye, aye.
Representative Wheeler?
Yay, yay.
Chairman Roy?
I can't think of a nautical response. So yes.
20-0.
Okay, the amendment is adopted. With that, I make a motion to vote to pass with amendment. Second, somebody, please.
Absolutely.
Seconded by Representative Prue.
Now all
With
the
that,
voters will hate
the bill is open to discussion. Anyone wish to discuss? Representative Sitek?
Does anybody remember why Hines reduced this to a violation? It sure seems like it's a misdemeanor class to me.
I believe the amendment says guilty of a misdemeanor.
I believe the rationale was he didn't want it to create a criminal record.
Yeah. But I believe we took that back to a misdemeanor, correct, with the amendment? Okay. Yeah, it looks like we took it back to a misdemeanor. Let's see. Let's make sure. Penalty.
Section 1 says you're guilty of a violation.
Stand by. Let's take a look at this.
There are two sections. The first section of the that was the amendment, the second which you've changed, but the first say in a careless and negligent manner so that the lives and safety of the public are endangered. It's a violation. I'm not happy with that.
Actually, Mr. Chairman, I remember when we were hearing the bill that presently it's a misdemeanor.
Yep.
And he wanted to make the careless and negligent operation a violation, but reckless operation would be the misdemeanor.
And does this accomplish that?
It does.
Okay, so we don't have a conflict. I'm looking at the bill, but what really matters is the actual statute, because the bill just amends the statute. So the operation of motor is reason by injury, absence, removal from place, given arrival scene. Any person operating a vessel that is in a manner involved in an accident shall report. If the operator is physically and mentally capable to make such report, or fails or refuses to make the report, provided required information, the owner of the vessel involved in an accident of the owner's representative shall, after learning the accident, forth and over. So where's it say misdemeanor? I mean violation.
No, but she has something to help you.
Could I just
Yeah,
clarify?
please help.
Because so what he was doing was he was amending the negligent one in the first place, and then he was adding another section that differentiates between negligence and reckless operation of both. So that's why the second one is a misdemeanor, so that it's saying it's differentiating between.
I gotcha.
The two.
Okay, it makes sense then. Yes,
yeah.
good. Representative Sitek.
Mr. Chair, I was just careless and negligent and reckless were the same in my mind. That
see.
was the problem.
Okay, so we're all clear. All right, thank you. Thank you for pointing it out, though. I don't want to pass something that conflicts. Any further discussion? Representative Lynn.
I don't wish to be a nitpicker, but I think that you may have a problem. In section 1, it says any person who shall operate a power boat upon any waters of the state in a careless or negligent manner. That's fine because that's different than 2, which talks about a reckless manner. But then the second phrase in 1 is or so that the lives and safety of the public are endangered, and that is the same as the second phrase of 2, or so the lives and safety of the public are endangered. So since you have an or there on both of them, I think you've got, I mean, the same conduct could violate both statutes. And I suppose that means that you could just give it prosecutorial discretion. The prosecutor could charge under either one, I suppose.
Well,
But
isn't it differentiated, though, by one is negligent and one is reckless?
Yeah, except that the or would say, in other words, in a reckless manner, that's one thing, or so that, that's the thing I see as a potential problem. I mean, I suppose, as I said, I suppose you could say that the prosecutor has the discretion to charge under either one.
As long as it doesn't conflict, if it leaves prosecutor.
Yeah, I suppose.
discretion.
I suppose that's all right.
Representative Newell.
I was just gonna say, I apologize because I didn't seem to write the guy's name down, but we did have somebody who came and spoke about, does anybody remember who it was? Yeah, Captain something, and he was talking about, why the differentiation was important and why it was, because it's about, if you're intentionally doing something or if you're doing something unintentionally.
Yeah. Yes, it was. Yeah.
Captain Walsh?
Yeah. Yeah.
It was Captain Dunleavy. He's actually retired from the Marine Patrol, but he's the legislative spokesman for them.
Good. Okay.
So, I mean, the way you could solve this is just take the word "or" out of both of them. Take the word, in other words, operates in a negligent manner so that the lives and safety, and then the second one would be operates in a reckless manner so that the lives and safety. I think that probably makes it clearer, but it's not, I'm not, as I say, I'm going to vote for this. I'm not looking to I'm just.
No, I don't want to pass any messy laws out of here.
I just raise it because the way it's worded now, in each of these, you have two offenses: negligence or the other, or reckless or the other, and the or the other is the same on both of them.
To your point. Okay, yeah. To your point, I don't want to pass a confusing. I want your amendment idea would make it clear to the judge. Versus this would be like, well, I'm not sure which the legislative intended.
Right. I think that. Yeah. I mean, I think you could clear it up just by.
What I would recommend to the committee, I think, is we'll go ahead and pass it, and I'll do a floor amendment to clear that up, and that way we can dispose of it today. Representative Salik.
I was just gonna wonder if we would recess this till next Wednesday or whatever the day is. We're doing the one other bill and then have the corrected amendment for that day, so we can vote on a clean amendment once rather than two amendments on the floor.
Yeah, that's actually probably a better idea because then it's clean and we don't have to worry about explaining this to everybody on the floor. Okay, so we'll recess this to March 6th. 8th, excuse me. Yes. Oh, you want to be here for that one? Yeah. Okay. This executive session is recessed to March 8th at 9:30 a.m. with the remaining ones, if that's okay. The clerk is looking at me. Do I need to stop for a second? Not at all. Yep. Before I bang any hammers, we're going to take a 2-second.
I'll steal you and Representative Bolden.
Representative Bolden?
Mr. Chairman. Mr. Chairman,
Yes, Representative Prue.
any chance we could move all the bills that we're supposed to exect on the 6th to the 8th? So we don't have to come in on the 6th?
Yes.
Are on you.
Yes, but
That
with
way,
a caveat that we may have to, because there's going to be more bills.
Then we'll
that-
stay late.
There was a bill that was referred to us yesterday. I tried to kick them all back into play. I was playing goalie yesterday, and I went up and waived a couple, but there are some that do belong here. So if we have to, as I get them, I'll schedule them as well on the 8th. So yeah, for the record, all the scheduled executive bills, what were they that I put, please? Do you have them? I want to read it onto the record so anyone in the public is listening. 1539. Okay, House Bill 1539, 1711, and 1366 are now scheduled for 9:30 a.m. on the 8th of March. 1012 is the boat bill? No, the parenting. We're going to. Oh, we have the amendment. We're going to do that today then. But let's finish the boat. We're still in the middle of the boat thing.
No, boat, you recessed.
We'll recess
Oh,
the
good.
vote
Oh,
to
good.
the
The vote
8th.
is-
Only have 10-12.
All right, so let's do 1012. This has been one heck of a day. All right, with that, reopen the executive session on House Bill 1012, and I recognize Representative Murray for a motion. This is all your stuff, right?
I do that every once in a while.
Thank you, Mr. Chair. I would like to move adoption of amendment 0855H.
Would you like to speak to your motion?
I would, Mr. Chair, thank you. After a conversation with the committee, it seemed like there would be more broad support if we could limit the scope of the bill to just make legislative intent clear and ensure that parents aren't being prosecuted unnecessarily for allowing their kids to have some fun in the woods without limiting too much judges' discretion when reviewing potential cases of child abuse.
Thank you. I'll speak to my second. I think that with Representative Lynn's help today, we took a bill that could have been confusing. The intent was clear. And so what we ended up doing was just going back to the intent. And we're expressing the intent to the court. And it clearly said it's not a violation of this section for parents to allow children to take reasonable risks to further their development as independent human beings. So that really gives parents actually broad discretion to parent how they wish. And it leaves it the standard of reasonableness, which we have great experience with in our jurisprudence. So I think it's going to be a good bill, and I think everyone who said they would will be happy. Any further discussion? Seeing none, I'd ask the clerk to call the roll on the adoption of the amendment.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sitek? Representative Prue?
Yes.
Representative Janvin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Lynn?
Yes.
Representative Tenzar?
Yes.
Representative Harry Gathray?
Yes.
Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Salick?
Yes.
Representative Wheeler?
Hey.
Chairman Roy?
Chair votes yes.
20-0.
20-0. Any objection to consent? Seeing none, we'll go on to consent count. What? Oh,
That's the
I'm
amendment.
just trying to get out of here. Would you guys just cut me a break? With that, the amendment is adopted. I would ask Representative Murray if she has a motion.
Thank you, Mr. Chair. I'd like to motion ought to pass with amendment on House Bill 1012.
Second. Would you like to speak to your motion?
Thank you, Mr. Chair. I think I covered it with the amendment. We want to make sure that parents and kids have the ability to be free and enjoy their lives, and also that judges have discretion to ensure kids stay safe.
I agree. Any further discussion? Seeing none, I ask the clerk to call the roll. Motion floors ought to pass with amendment.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sitek? Yes. Representative Prue?
Yes.
Representative Janvin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Lynn?
Yes.
Representative Tenzar?
Yes.
Representative Harry Gathray? Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Selig?
No.
Representative Wheeler?
Yay.
Chairman Roy?
Chair votes yes.
19-1.
19-1. Representative Selig, do you object to consent? There's no objection to consent. Go on the consent calendar, and the bill is adopted. And with that, we are done for the day. I will see you all on someday in March. I don't know. Whenever I expect to be brought something back from Florida. Hey, thank you all for your hard work today. Hey, listen, this is important. I want to say this. We really, really did our job today. We dug into bills, we debated, we expressed our opinions. Nobody got hit, which is great. And some of us may have expressed our emotions too much. And if anyone was offended, I apologize. If not, it's fine.
Well, a lot of that credit goes to you, Mr. Chairman, so thank you very much.
Flattery will get you nowhere. Thank you so much.
Thank you.
We
we have
could
a
not
list
have
of
done it
reports?
without you,
Who's
Mr.
doing
Chief
reports? Do
Justice.
you have that list? All right, just so I know if I'm doing one, I want to be able to do it.